Yes, sir. Report the roll, sir. Thank you very much. We're going to try to move through this morning's agenda with some efficiency. We're going to start with, if I could direct the attention of the committee to Senate Joint Resolution number 35 and the accompanied Senate Bill 300, which deal with the transportation. 400, I'm sorry, 400, I apologize. Thank you very much. The patron has asked that we strike those bills. Senator Hanger moves and Senator Newman seconds that Senate Joint Resolution 35 and Senate Bill 400 be stricken from the docket at the request of the patron. All those in favor signify by saying aye. Aye. All those. Oh, I keep forgetting about that. That damn thing's so inefficient, you know. Yes, sir. Close the roll and report it, please. With the two bills are stricken from the calendar. Yeah. All right, we'll start with the non-members. Senator Chafin, are you here? If not, Senator DeSteffe.
Mr. Chair, members of the committee, good morning. We have Senate Bill 559, Secure Return of Ballots, or Secure Voting for Deployed Military. West Virginia last year did a pilot program on this. We're requesting $100,000 to do a very similar pilot program. What they noticed was they had twice the number of absentee ballots returned, the same amount that they always get via mail, but twice that from the electronic voting. In their report, they said it provided their uniformed service members overseas a safe, simple, and timely way to cast a ballot while deployed. And they got their vote and it counted. So what I'm asking for is $100,000 to do the same pilot program or a similar pilot program here in the state of Virginia. What you'll hear on the other side is the technical aspect of whether it's secure or not, and that debate's already happened in committee multiple times. But today on the $100,000, that's all we're asking. That's the bill. And for a budget offset, if you look at one of my budget requests, we actually have a reduction of $6.2 million at DPOR. So with that, that's the bill. We're asking for $100,000, and I've provided a very large offset for that.
Does any member of the committee have any questions of Senator DeSteffe regarding his Senate Bill 559?
Mr. Chairman.
Senator Hanger, yes, sir.
It's my understanding this bill already contains a financial contingency clause. Is that correct?
Yes, sir, I believe it does.
Okay. Mr. Chairman, I move the bill be reported.
Well, before we get to there, is anyone who wants to speak in favor of the bill?
Hey, Alex.
Anyone who wants to speak in favor of the bill? Anyone who wants to speak in opposition to the bill?
We've got the JLC here, Mr. Chairman.
All right, let's move along very timely, please.
Just say we support this wonderful bill and we'll get
it. For the Joint Leadership Council, and I just want to reiterate that this bill is a very high priority item for the Joint Leadership Council. We support it.
Thank you for being with us. Anyone else want to speak in favor of the bill? Anyone want to speak in opposition to the bill?
Good morning, Senator. Alex Blakemore with Verified Voting. And yes, sir, the aims of the bill are laudable. It's but it is a very risky policy. You should be aware the federal government spent well over $100 million over 12 years tried two systems and abandoned both, saying that with the research, with the expertise of the National Institutes of Standards and DoD, decided that it was the technology did not exist to do this in a secure way. We contend it's not realistic to expect the Department of Elections to do what the federal government couldn't do with $100 million plus with 100,000. With that policy, what you're basically would be telling the Department of Elections to do is to trust whatever the vendor tells you. And of course, vendors will take whatever money you offer them and give you security assurances. Experience showed recently in Virginia that just about every election system we had in use came with great claims about the security from the vendors, and once VITA looked at them, they decertified just about every one of those machines. This is a very risky policy. If you are going to go forward, we encourage you to add a couple zeros, or at least 1 zero, to the end of the appropriation to be realistic. Thank you.
Thank you very much for being here. Anyone else who wants to speak in opposition? If not, ladies and gentlemen of the committee, there was an earlier motion by Senator Hanger that Senate Bill 559 be reported as it has the clause on it. Was there a second? Second. Any further discussion? If not, if you would open the roll. I remembered it this time.
Mr. Chair, members of the committee, thank you very much. Have a great day.
If you would report the.
Ayes 14, noes 2.
Ayes 14, noes 2. Senate Bill 559 is reported with the clause. Senator McPike, are you here, sir?
Morning, Mr. Chairman.
Good morning, sir. How are you?
Outstanding. I have before you Senate Bill 652, which reported from general laws with the substitute. I think the original bill prior to substitute, which was much wider. The substitute really narrows down on the certifications of employment service organizations and looks at also convening some folks together that have been working on the legislation with me. And that is the quick summary of the bill reported 15-0 from general laws. And we do have several folks in support of the measure here today, Mr. Chairman.
Any member of the committee have any questions of Senator McPike regarding Senate Bill 652? If not, is anyone who'd like to speak in favor of the bill? Yes, sir. Come on up.
Morning, my name is John Smith. I'm with the Virginia Board of People with Disabilities. We support the bill. We think it's a good step to bring stakeholders together to figure out how to use our procurement policies to benefit employment of people with disabilities.
Thank you, sir. Good morning.
Good morning, Chairman and Committee. Karen Tefelsky with Virginia Access. We support the bill wholeheartedly. Thank you.
Good morning, Mr. Chairman, members of the committee. Sandra Gill, Department of General Services. We support the bill and look forward to working together.
Thank you very much. Anyone who has an opposing view? Oh, I'm sorry, didn't see you there.
It's okay. Hi, Chairman, members of the committee. My name is Jenny Halborn. I'm with the Disability Law Center of Virginia. We're Virginia's protection advocacy system, and we support the bill. Thank you guys for your hard work on all of this.
Thank you. Anyone who has an opposing opinion?
Mr. Chairman?
Senator McDougall, yes,
Mr.
sir.
Chairman, I have a question. I see that there's one representative of the Office of the Governor, 2 representatives of the Office of Secretary of Administration, so really 3 representatives of the Governor, but I'm not seeing any representatives from the legislature. Am I missing something, or was that intentional?
It's really good, to get them primary stakeholders, if the committee so chooses. Certainly not opposed to that. We really wanted to get, it's a fairly complex level, which you've seen the stakeholders who have approached today. We've been working several weeks on tweaking and fine tuning. So I'm, Mr. Chairman, agnostic in terms of the senator's question.
Mr. Chairman?
Senator McDougall.
It would seem maybe the staff director or their representative from the Senate Finance and House Appropriations that having one of our budget people in the room is a good idea. So I would move that we add in staff director or their designee from Senate Finance and same from House Appropriations Committee.
It's been moved and seconded. Did council catch the proposed amendment? Okay, if you would repeat it so everyone's on the same page, please, ma'am. In concept.
Mr. Chairman, in concept, we would take the membership that's listed in beginning line 43, change that from 10 non-legislative citizen members to 12, and the additional 2 would be the staff director of Senate Finance or the staff director of House Appropes or their designees.
Does everyone understand the amendment? It's been moved and seconded. All those in favor of the amendment, please signify by saying aye.
Aye.
All opposed? Ladies and gentlemen, the bill as amended is before you. It's been moved and seconded that the bill be reported as amended. If you'd open the roll, please, sir.
Roll is open.
Report the roll, please.
Ayes 15, no 0.
Ayes 15, no 0. The bill is reported.
And Mr. Chairman, Senate Bill 644 was taken up in subcommittee. I don't know if the committee is going to take those up in a
We're
subcommittee
going
report.
to take those up in a subcommittee report, sir.
Thank you,
And
Mr. Chairman.
I think you know the disposition of that bill. All right, next is Senator Peterson. Senator McClellan.
Good morning, Mr. Chair. And
Good
members
morning.
of the committee, I have Senate Bill 353, which authorizes the Department of Conservation and Recreation to convey real property adjacent to the White Oak Technology Park in Henrico County to the county's Economic Development Authority in exchange for an open space easement for part of the
Is this one of a
natural
series
area.
of conveyance bills that we have?
Yes.
Any member of the committee have any question of, we've got a number of these conveyance bills. Does any member of the committee have any question on Senator McClellan's bill? Anyone who wants to speak in favor?
DCR and Henrico are here if you have questions, but they support it.
We don't have questions.
Okay.
Anyone against it? All right, that's been moved and seconded that Senate Bill 353, conveyance bill be reported. Any discussion? If not, if you'd open the roll, sir. If you'd report the,
Ayes 16, no 0.
Ayes 16, no 0, the bill is reported.
Thank you.
Thank you for being with us. We appreciate it. Senator Edwards. Good morning, sir.
Mr. Chairman, members of the committee, this is a request of the Attorney General to...
Which bill, sir?
I'm sorry, Senate Bill 487.
Senate Bill 487, if you'd please direct your attention to that,
The
please.
Virginia Fraud Against Taxpayers Act. This is a requirement of federal law to avoid losing some federal monies, that we need to index Virginia penalties for fraud claims under the Virginia Fraud Against Taxpayers Act pursuant to the Deficit Reduction Act under federal law. That's the short version of it. And it's basically to index it so that the bill would require that the penalties be increased from not less than $5,500, not more than $11,000, from that to not less than $10,957, to not more than $21,916. So it's a fairly technical bill. I think somebody from the AG's office may be here. If you need some more details.
We don't need excruciating detail. Yes, sir. Step up, please.
Good morning. Clay Garrett with the Attorney General's office. As Senator Edwards said, this is a bill to continue compliance with the Deficit Reduction Act, which is now Section 1909 of the Social Security Act. Failure to enact these changes will reduce recoveries on the Medicaid fraud settlements that we enact.
Senator Newman.
Either to the patron or to the department, where do the fees go? Are you going to keep them in the Attorney General's office, or do they come back to us?
No, sir. All the recoveries we make on the civil side of the Medicaid Fraud Control Unit come back to the General Assembly budget for the health, there's a healthcare set aside.
Great, thanks.
Any other member of the committee have any questions of the AG or the patron? Anyone else like to speak in favor of the bill? Anyone like to speak in opposition to the bill? It's been moved and seconded that Senate Bill 487 be reported. Any discussion? Hearing none, if you'd open the roll, sir.
Roll is open.
You report the vote, please, sir.
Thank you, Mr. Chairman.
Ayes 13, no 0.
Don't you have another bill?
No, not today, tomorrow.
Mr. Chairman?
Yes, sir.
Mr. Chairman, Senator Edwards does have another bill. It's Senate Bill 986, but there had been some tentative agreement on a substitute for this that we've not had a time to draft. We have just a copy of it. So you want to try to see?
I've been told they're still.
I'll tell you what, how
Still
about
talk-
without
okay.
objection, we'll pass it by for the day so
Sounds good.
that substitute can maybe get settled. Jesus Christ. Senator Stanley.
Morning, Mr. Chairman.
Good morning, Senator Stanley. How are you?
I'm doing well, sir. It's always nice to see you. I
Do
mean
you have
that.
a bill other than the one that was in the Public Safety Subcommittee?
I do.
Yes, sir. We'd like to hear from you.
Thank you, sir. I was told to return just in case after a tie goes to the runner on that one. Mr. Chairman, Senate Bill 883.
Senate Bill 883, if you direct your attention to that. Yes, sir.
Mr. Chairman, members of the committee, you probably heard from Delegate Will Moorfield, as we all have repeatedly every day for the past 18 or 19 days about this bill. Basically, it's a simple bill that creates an enterprise
Is he
zone
in the
of sorts.
Senate?
No, but he certainly spent a lot of time on our floors.
It's been moved and seconded that the
Oh, there's a
amendment in the
substitute.
nature of a substitute be adopted. All in favor signify by saying aye. Aye. And that's adopted. Yes, sir. Now, tell us what the substitute does, maybe the original bill did
Yes,
not
sir.
do.
Mr. Chairman, it encompasses everything that this bill was up to this current form, but it's a simple bill. It basically allows in certain areas where, quite frankly, we have lower incomes, higher unemployment rates, higher poverty rates, areas of the rest of Virginia that have not seen the economic upturns and benefits that perhaps Hampton Roads and Northern Virginia have seen over the years. But at the same time, Mr. Chairman, as you've heard me say to this committee and other committees many times, 20 or 30 years ago, these are the areas that were industrious and were the industrial leaders and builders of Virginia with textile manufacturing, furniture, coal, and the like. We now have some of the highest unemployment rates. Just in my district, nearly 1 out of 3 children live at or below the poverty level. What we're trying to do is have a game changer where we're bringing in industry, quite frankly, that will increase revenues, will increase jobs, increase populations, and make, once again, South Side, Southwest, and our urban areas on equal footing with our other partners in Northern Virginia and Hampton Roads. In this bill, if a company sets up shop in one of the qualified localities and meets the minimum investment criteria, which would be $5 million of capital investment, and create a minimum of 10 full-time jobs at double what is Virginia's minimum wage, or if the company simply creates 50 full-time jobs at double the minimum wage in Virginia, then the company would be exempt from the Virginia corporate tax income tax for 10 years, and their employees would be exempt from personal income tax for a period of 10 years. Existing businesses in Virginia don't qualify. What this is trying to do is bring in new businesses, attract new companies, and new people to the Commonwealth of Virginia in order to diversify our economy, and quite frankly, doesn't negatively affect the general fund, because what we're talking about are companies that don't exist in the Commonwealth of Virginia. And so what we're trying to do is attract them here, get them here. Once they set up shop within that 10-year period, of course, they're going to be generating revenues for the Commonwealth of Virginia, generating jobs and local revenues for our local governments. Basically, this is one of the ways that we can help the economies in areas that otherwise are not in a position to even help themselves. And that's the bill, Mr. Chairman.
Senator Stanley, one of the concerns was that the fiscal impact previously had been undetermined, but there was a potential significant negative impact on the general fund. Has your amendment in the nature of the substitute done anything to address or mitigate that, sir?
Yes, sir, I believe it has.
Does any member of the Senate Finance staff have some information to enlighten us?
Mr. Chairman, the substitute does add a provision that requires the Virginia Economic Development Partnership to evaluate the companies to determine if, in their view, the company would have a net positive fiscal impact. Staff still has some reservations about that methodology and feels like the substitute would have a negative impact on the general fund.
Senator Sasslaw and then Senator Hanger, please.
Let's say after 10 years, Tennessee offers them the same thing and they leave. Do they have to return all the corporate income tax they didn't pay, and do the people who didn't pay that income tax have to pay that back too?
Mr. Chairman, I'd answer Senator Sasslaw by saying, you know, I'm unsure about that, if there's a penalty for those companies that come in and do not reap the benefit. What it is really a sunset provision for 10 years that these companies come in. It really doesn't play on the have to be there for 10 years, have to maintain certain things, but it does require a substantial investment on that part of that company of a minimum of $5 million of capital investment into the Commonwealth of Virginia, which brings its own rewards, and 10 full-time jobs at double the minimum wage, or 50 jobs at double the minimum wage. So what we're trying to do is, once we know that we can bring them here and attract them here, Senator Sasslaw, and Mr. Chairman, I'd answer you that I think the wherewithal and the intestinal fortitude of my area would keep them there, subject to any economic changes in the environment.
Does that answer your question, Senator Sasslaw? Senator Hanger, please.
Thank you, Mr. Chairman. I've actually been trying to work on this a bit with the House patron and this patron to come up with something that was workable, because we all recognize the need for investment and job creation in Southwest Virginia. Quite frankly, I'm concerned that the bill isn't quite there yet, and here's the reason why. There's a suggestion that we're not giving up any income, but our budgets are based on a certain projected revenue growth, with the majority of that general fund coming from income tax, withholding and non-withholding income tax. If you basically are creating a situation where some of that job creation is without withholding tax, without income tax, you effectively are negatively impacting our revenue forecast. Even in even with the limited circumstances you're talking about, we are having this type of job creation in Southwest Virginia and South Side, and our plan is to encourage more through incentives through BEDP, Go Virginia, and the Commonwealth Opportunity Fund. So, Senator Stanley, I'm a little bit torn on this, because I'd suggested I'd try to help this through the process, but it has a significant potential for negative outcome on our revenue.
Mr. Chairman, I'd answer Mr. Chairman by saying,
Yes, sir.
Basically, right now, if you look at the population decreases in these areas which are cited, if you look at the revenue that's not being generated because we don't have the populations, who are then, part of this is there's a trickle-down effect, and I hate to use that word necessarily, but there's an ancillary effect that is a positive revenue generator when you're bringing that many, let's say 50 employees come in, double the minimum wage. Then you're going to have other stores opening up, mom and pop shops, small businesses, entrepreneurs that are going to be coming in, and when their purchasing power is there at double the minimum wage, minimum 50 employees, they're going out and they're buying goods from our local industries. They're paying sales tax. They're paying taxes, at restaurants. They're helping the local governments and their local economies. What we're trying to do is reverse and infuse in these areas where are suffering population declines. And when you suffer population declines, Mr. Chairman, that's a little confusing, but when you suffer these population declines, you're losing that revenue. Those mom and pop stores are closing up, and what we're seeing now is this very committee is struggling with trying to compensate our school systems where our populations of our students are dropping. So then that's a negative impact in and of itself.
All right, let's see where we're going here.
Mr. Chairman,
Mr. Chairman,
I just have one question for the patron, and so I set up a little company. And I'm a high-income individual, so I set up a little company. We're going to install solar panels out in any one of these localities that say that. And a typical solar installation probably runs, if it's going to go to a transmission line, well over $100 million. So I've made my investment of $100 million. And as I read this, I make the $100 million. I have 10 people that I call installers in my company that put that up and continue to maintain that. Then I'm going to get a $250,000 personal income tax subtraction from my income. I mean, that's Did I miss anything there as I read the bill? I mean, I made the investment, I put the companies into place. I've invested well over $5 million. I've invested close to $100 million. I put people to work. I hire people. I moved 6 of my electricians from another company over to my new LLC, and now I get to write off $250,000 off my income taxes. Creates a personal income tax subtraction of $250,000 for 10 years for employees of eligible companies. Did I miss anything in there?
Mr. Chairman, I would answer the gentleman. I think in the factual hypothesis that you're saying, maybe moving employees from one Virginia company to another, remember the VEDP and others would review. You are remitting the tax to the state, the estimated tax to begin with, and then the state makes a review to make sure that you qualify under this bill before you would derive any benefit. You are correct that it is a $250,000 max cap for the company.
All right, any further questions? Is anyone who wants to speak ever so briefly in support of the bill? Anyone who would like to speak in? Good morning, sir.
Mr. Chairman, very briefly, Ryan Dunn with the Virginia Chamber of Commerce. We support this idea. We've been working with the senator and the delegate over on the House side, trying to really find a way to get the revenue and the opportunities to where they're needed the most. So we've been helping advance this idea. We think it's a big shift and a good idea to start continuing the conversation around. So for that reason, we've supported the legislation. Thank you.
Thank you. Good morning, sir. How are you?
Good morning, Mr. Chairman. I'm fine, thanks. How are you? Mr. Chairman, as you and others on the Finance Committee have known for our conversations, I have written a book about these parts of Virginia that I call the extremes of Virginia. The localities that are mentioned in the bill very closely match those areas. In the interest of time, I want to very briefly underscore the plight of these areas and draw attention to it for those members who may not be familiar. As Senator Stanley mentioned, the population in the extremes is shrinking, and especially the young people are moving away. In a 5-year period ending in 2014, population of the extremes decreased by 2.5%, while Virginia as a whole grew more than 4%. High school graduation rate considerably less than the rest of Virginia. The college graduation rate less than half the rate of the rest of Virginia. Many more people lack health insurance. The civilian labor participation rate fully 10% lower. Income 40% less. The poverty rate 67% higher. Suicide rate is 19% higher. Opioid death rates 56% higher. All of that is a crude and quick way of saying these areas desperately need the help of the General Assembly. Perhaps this bill is a first step, an initiative to try to give these areas some hope for jobs, some opportunity for economic growth, so that people who live there can join the rest of Virginia in the prosperity that we are enjoying. I know the bill has caused some concerns among the legislature. I hope that the legislature continues to pursue the bill, continues to modify it if necessary, to fine-tune it if necessary, because to my knowledge, this is the only legislative item on the table this session that attempts to solve, or at least take a step towards solving, the issue of a decided lack of jobs that are needed in the extreme. So I urge your consideration. Thank you, Mr. Chairman.
Okay, thank you for your advocacy for Southwest, South Side, and Eastern Shore on this. Anyone who wants to speak in opposition to the bill? If not, ladies and gentlemen of the committee, Senate Bill 883 is before you.
Mr. Chairman.
Senator Sasslaw.
I move that Senate Bill 883 be passed by indefinitely.
It's been moved.
Substitute motion.
I'm sorry?
Substitute motion.
Yes.
Move the bill be reported.
All right. The substitute motion is that Senate Bill 883 be reported.
Mr. Chairman.
Any discussion on that motion?
Chairman,
Senator
I
Newman,
apologize,
yes, sir.
I was out of the room
That's
for just
all
a
right.
moment. Did we put the clause on this, or is this?
No, sir.
Okay, all right. I mean, I'd like to vote for it. I don't know I don't know where the money's coming from. I know that it's only if they bring them in, but I just don't know long-term where the money.
Okay, Bill. Senator Hanger.
I was going to ask Senator Carrico if he might withdraw that motion until we could put the clause on it.
I'll put the clause on.
Sure.
Well, then he has to, that's right, his motion.
Senator Carrico, you withdraw your motion to pass the
Yes.
bill? All right.
I can renew my motion after the clause is put on there.
Maybe.
Okay.
Senator Sasslaw, you want to temporarily withdraw your motion to pass it by indefinitely? All right. All right, Senator Hager.
Mr. Chair, I move we attach the financial contingency clause so we can evaluate the revenue impact.
Okay.
Second.
Second. It's been moved and seconded that the financial contingency clause be affixed to Senate Bill 883. Is there any discussion? If not, all those in favor signify by saying aye.
Aye.
Aye. All those opposed, and so the contingency clause is now attached to Senate Bill 883. Are there any motions?
Move
Now I
the report
remove.
as amended.
Second.
There's a motion to report as amended. Any further discussion? If not, all those in favor of reporting Senate Bill 883 as amended, please show your vote on the board, which will be opened. Report the vote, please.
Ayes 11, noes 5.
The bill is reported as amended, 11-5. Senator Stanley.
Thank you, Mr. Chairman, members of the committee. I appreciate your time, sir.
Thank you, sir, for your advocacy.
With regard to my explosive fireworks bill, are you going to just take it up, or do you want me to return?
No, sir, we're going to take that up when Senator McDougal does a report, and you're
Yes, sir.
welcome to stay, but I think you know the direction that is moving, sir.
Mr. Chairman, I think I have a chance. 3-3 tie. We're just in the ninth
Well,
inning,
you
that's
know,
all.
there's another old song I remember, and it's called Dream the Impossible Dream.
Mr. Chairman, if we don't have dreams, what do we have? We have the Senate Finance Committee. That's what we have.
We're not having explosive dreams today, I can tell you that. All right, Senator Peterson.
Yes, sir.
Good morning, sir.
Thank you, Mr. Chair. Mr. Chair, members of the committee, I think I have two bills before you.
You do, sir.
First one is Senate Bill 224. This was the one that kind of came in like a lamb or excuse me, like a lion and is leaving like a lamb. The substitute that was passed by the courts committee basically allows someone whose property has been seized by the Commonwealth or by the police to file a petition after a year to get the property back. There would be no obligations. Obviously, this would be property that's not subject to a forfeiture, and there had been no criminal indictment filed. So it would be those situations where you had an investigation and no charge was brought, but the Commonwealth, for whatever reason, did not want to release the property. Again, this just allows a petition to be filed and an in-camera proceeding to occur.
Thank you very much. Any member of the committee have any questions regarding Senator Peterson regarding Senate Bill 224? Anyone who would like to speak in favor of it? Anyone who would like to speak in opposition to it? Yes, sir.
While he comes forward, can I ask Senator Peterson a question?
You may indeed. Senator Carrico.
So, Senator Peterson, under the asset forfeiture law currently, what prohibits them from petitioning it already?
Well, under asset, if I might respond, under asset forfeiture, they'd have to file that within 90 days of seizure. So this would be a situation where they didn't file for forfeiture, so it's not a forfeiture action. They're simply holding the property.
All right.
Good morning, Mr. Chairman, members of the committee. I'm David Ledbetter. I'm the Commonwealth's Attorney of Waynesboro. I'm here on behalf of the Virginia Association of Commonwealth's Attorneys, and we are opposed to the bill as it's currently drafted. We don't have no issue with the concept that if we seize individual's property and have not brought criminal charges, they ought to have the right for redress. They ought to have the right to get into court and to petition for that. And this bill goes to the seizures. It doesn't go to asset forfeiture, because as Senator said, any asset forfeiture, I got to file in 90 days or I'm required to give the property back. So that's automatic. So there's a filing on that. This goes to other seizures. The issue we have with the bill, the concept is good. The devil is in the details and could have a significant impact on our offices and how we do business, because we don't know what the procedure is. We don't know what discovery is going to be. We don't know if there's a right to a jury trial. There's a whole host of details that we can work out. It just has not had time to work out for us to work all the details out on this bill. The senator's worked with us. He substantially changed the bill as it was in its initial form, and we're happy with that. But there's still more details to be ironed out.
Senator Overchain, did you have a question or did you want to make a comment, sir?
I have more of a comment and a motion.
All right. Thank you very much. Anyone else who would like to speak in opposition to the bill? All right, Senator Obenshain, yes, sir.
Mr. Chairman, you know, I agree with Senator Peterson in principle. And I think that he and the Commonwealth's attorneys have worked hard on this, have come a long way, addressed a lot of the concerns. But this bill relates to evidence. And I think that the Commonwealth's attorneys and Senator Peterson, I think, would benefit from a little bit more time to work on this. And from my discussions with the Commonwealth's attorneys from some of the larger jurisdictions, they've expressed a desire to try and find a solution. They don't disagree in principle. My understanding is that they'd like to continue to work on this. So reluctantly, I would move that this be passed by for the year.
Is there a second?
Can I?
Is there a second to that motion? Okay, second. Okay.
If I could just make one point, and I kind of see where this is going and what happens. My colleague, Mr. Ledbetter, we've worked on this, said they're required to give the property back if they don't file a forfeiture. Actually, they're not required. They can hold it indefinitely. So, again, this is when you're just trying to get your own property back. But that's all I wanted to say.
All right, ladies and gentlemen, the bill is before you. The committee operates by motion.
Mr. Chairman, I moved to carry the bill over for the year.
It's been moved and seconded that the bill be carried over for the year. Is there any discussion on that motion? If not, all those in favor of carrying over Senate Bill 224 for the year, please signify by your vote on the board. Open it. We're good? Report the vote, sir. Ayes 16, no 0. The bill is carried over for the year. I believe next is you have Senate Bill 824. Ladies and gentlemen of the committee, that is on page 4 of your purple sheet.
Thank you, Mr. Chair. This is Senate Bill 824 that was killed in subcommittee and then like Lazarus rose again in the Education Full Committee. To some folks probably dismay. Basically, what it requires is a public hearing prior to a tuition increase. You will remember last year we passed a bill that says prior to any tuition increase, there has to be 30-day notice with an explanation, just as our local governments have to undergo before they have a vote on their vote to raise local taxes, so or at least property tax. My bill simply took on the concept that we had from last year and just simply adds a meeting requirement. I phrased it in the most benign way possible. I just say, prior to any vote referenced in subsection D, which is a vote to raise tuition, the governing board of each public institution of higher education shall permit public comment on the proposed increase at a meeting of the governing board. They can set regulations, they can limit it to whatever is reasonable, but again, it's just a chance for people to be heard. That's it.
Senator, wasn't this concept somewhat embraced in Senator Peake's bill yesterday that was rejected, 2416?
Mr. Chair, I did not speak to that bill because I didn't think it was, because there are so many other meetings like planning commissions and boards of zoning appeals, but I think tuition's different. I think folks ought to have a right to speak, but that's just me.
Any member of the committee have any questions of Senator Peterson on this bill? Is there anyone who would like to speak in favor of the bill? Is there anyone who would like to speak in opposition to the bill? Boy, talking, oh. Oh.
This is my maiden voyage, so be nice to me. So.
I'm sorry, who are you, ma'am?
Betsy Daly with the University of Virginia. Thank you, Mr. Chairman, and thank you, Senator Peterson, for letting us comment. Actually, I don't think we oppose the bill. It's the spirit of where we think Senator Peterson is going is very much internalized in the day-to-day operations of the University of Virginia. Input engagement is expected from students, from faculty, from parents, from alumni, staff, and access to board members' emails, their contact information. The president routinely gets information from and comments from staff and all sorts of folks, from students. And as you may imagine, our students are very engaged, they're very vocal, and they're not shy about having their views heard. As Senator Peterson observed last year, we, along with with William and Mary, were the first two schools to implement the 30-day notice. And during that period, our finance and budget staff did meet with the student group and talked about some of the logic and the thinking behind the increase. And then also this year, the board instituted a student comment period during the meeting of the Academic and Student Life Committee. And this was coordinated by our student member of the board. So as well as board members are constantly apprised of what's going on grounds on these areas. And so I just have to say that engagement and providing avenues for input and comment it's a year-round process at the University of Virginia. It's not limited to just one meeting, and I would be concerned if the thought was that one hearing could substitute for that year-round engagement. Thank you.
Thank you very much, and nice to have you back with us. Good morning, sir.
Good morning, Mr. Chairman. Colin Smolinski from William & Mary would like to echo the thoughts of my colleague from UVA and also reiterate that the stakeholder feedback process is a year-round process on campus for us.
Thank you for being with
you.
us. All right, ladies and gentlemen of the committee, Senate Bill 824 is before us, and I would say in concept it is similar to Senator Peake's bill yesterday that we addressed. The bill is before you. Okay, was seconded? Yeah. Okay. It's been moved and seconded that Senate Bill 824 be PBI'd. Is any discussion? If not, will you open the roll, please? If you would report the roll, please. If you would close the roll and report it, please, sir. Okay, 13-3. All right, with that, the bill is passed by. Thank you, Senator Peterson, for bringing that bill before us, sir. Let me get him off here. McPike. Senator Lewis, you're next, sir. Senator Lewis, pursuant to advance notice that you gave us, we had taken a motion to strike from today's docket SJ 35 and the accompanying SB 400. So I hope that's consistent with
Yes,
your
sir, that is consistent. Thank you, Mr. Chairman. I want to thank Mr. Powell and Ms. Wallmeyer for their help on that to avoid the dreaded unintended consequences of legislative action, Mr. Chairman. So appreciate that. The other measure I have before the committee is Senate Bill 219, I believe, Mr. Chairman.
All right, if you direct your attention to Senate Bill 219, that would be very nice.
And this is on its second passage through. It is a constitutional amendment, and it's pretty straightforward, Mr. Chairman, members of the committee. It authorizes the governing bodies of any locality to provide at their, should they so choose, a partial exemption from local real estate taxes upon such conditions as they may prescribe for folks who have on occupied property taken action to occupy property that's subject to recurrent flooding, taken action for flooding abatement, mitigation, or resiliency efforts. That's it in a nutshell, Mr. Chairman.
Right. Any member of the committee have any questions of Senator Lewis regarding Senate Bill 219? Is anyone who'd like to speak in favor of Senate Bill 219? Anyone who'd like to speak in opposition? If not, ladies and gentlemen, Senate Bill 219 is before you.
Move the bill be reported.
It's been moved and seconded. Excuse me?
Okay.
Well, we can do that. You have the companion bill, which I guess is 400?
Yes, sir, Mr. Chairman. I'm sorry about that. That's the language for the amendment. Yes, sir.
Mr. Chairman?
All right. I'm certain that the motion to report the bill included both 219 and 400.
Mr. Chairman?
219 and
219.
21. And SJ 21.
Yeah, I'm sorry. All right. I'll finally get it right. All right, any discussion?
Mr. Chairman, I had two questions.
Senator McDougal.
The first question is, this is not just for coastal areas, so this could be if you had a piece of property that was below a dam, that the jurisdiction could also do this. Is that accurate?
That is correct, Senator McDougal. It is not limited to the coastal area.
Mr. Chairman, my second question is, do we traditionally have a history of not moving forward constitutional amendments in this year, but carrying them over to next year because they have to be voted on after intervening election, which will not occur next year.
This is a second on this, isn't it?
It's not a constitutional amendment.
All right.
Staff advised me this is the second.
Oh, this is the second year.
Yes,
Okay.
sir.
Whoops.
Okay. Any further questions? If not, there is a motion to report SJ 21 and the accompanying SB 219. Any further discussion? If not, you'd open the roll, please, sir. If you'd report the vote, please, sir.
Ayes 13, noes 2.
Thank you, Mr. Chairman.
Ayes
Thank the committee.
13, no 2. Those two are reported.
Thanks,
Thank you,
sir.
Senator Lewis. We appreciate you being with us. Senator Wexton, a late arrival. How are you this morning?
Wonderful. Mr. Chairman, how are you?
Well, it depends on your bills. So. I believe you have two bills.
I have two bills, Senate Bill 419, maybe we can start with that one. We'll just go
Senate Bill
numerical.
419, if the committee would direct their attention to that, please.
This may look familiar to the committee because this is the equal pay legislation that passed out of committee yesterday on an, I think, 10-5 vote, something like that. It has no fiscal impact. It is legislation that would make amendments to Virginia's equal pay statute. We ostensibly have an equal pay law, but it's lacking in two important respects that this bill is seeking to remedy. This bill would add benefits and privileges to just plain old wages, such as retirement, deferred compensation, paid leave, to those items that employers cannot discriminate on the basis of sex. And second, it would prohibit employers from punishing employees for discussing or in any way sharing or disclosing their income information with one another and benefit information with one another.
Senator Wexton, I believe a concern that came up after you left, and we apologize for the discourtesy, and that's why we carried it over to today. But it's my recollection, and I think you shared with me, that embedded within the existing language is the ability for the recovery of attorney's fees and damages. Is that correct?
That's correct, Mr. Chairman. We need to give people the ability to, and that's only when petitioners or plaintiffs substantially prevail on the merits. So it's only for meritorious cases, for any instances where it's found to be a specious claim
Okay.
or without merit, there would be no award of attorney's fees.
Does any other member of the committee have any questions of Senator Wexton? If not, is there anyone who'd like to speak in favor of the bill? Well, we've heard it before, so if you'd be ever so brief, that would you get a lot
Yes, sir, Mr. Chairman.
ladies for that.
Anna Scholl with Progress Virginia. As we noted in Commerce and Labor when you unanimously reported this bill out, this is a basic provision. We particularly support the part of the bill that ensures that employers can't retaliate against employees for voluntarily sharing their wage information. We know that the inability to find out what other employees are making is a barrier to women learning that they're being discriminated against in the workplace. And that provision of the legislation we find to be particularly important and hope would gain your support.
Thank you very much. Yes, ma'am. I think we've had the privilege of hearing from some of you before, and we welcome you back.
My name is Galina Barchana, and I represent NARA Approaches Virginia, and we support this bill for the reasons stated.
Thank you so much, ma'am. Yes, ma'am.
Mr. Chair and committee members, Jennifer Allen with Planned Parenthood Advocates of Virginia, and we also support this bill.
Thank you, ma'am.
Good morning, Senator Norman and members of the committee. The administration supports this bill. We support equal pay for women. Thank you.
All right, anyone who might have a different opinion of this particular bill?
Mr. Chairman, members of the committee, Nicole Raleigh with NFIB. NFIB supports equal employment opportunity and appropriate enforcement. However, we do have some concerns with the bill. One, we believe there are adequate pay protections already that exist at the federal and administrative levels. As a matter of fact, you can file these both you have the federal court, you also have the employment EEOC to make claims against. We do believe that by mandating the awards of attorney's fees, we are concerned that this would open up exposure to small business owners with lawsuits. Many small business owners do not have HR departments and in-house legal counsel to deal with these types of complaints. And so we do feel that it could be costly for them. And frankly, it also expands protections dealing with benefits and privileges, which does reduce the small business owner's ability to offer and be flexible with what benefit package they would offer when trying to compete for high-quality workers. And so it's for those reasons we oppose.
Thank you for being with us. Yes, ma'am. Anyone else?
Mr. Chairman, members of the committee, Jody Roth on behalf of Virginia Retail Federation. We also oppose this bill for all the reasons just mentioned by my colleague, Nicole Riley. Thank you.
Thank you very much for being with us. Yes, sir.
Mr. Chairman, members of the committee, Ryan Dunn with the Virginia Chamber of Commerce. I just want to quickly point out a couple things. First off, equal pay for equal work is something we all stand behind, but this bill doesn't actually accomplish that. It really provides some other problems that we run into. The real big issue is it removes the FLSA coverage. Removing the federal FLSA from this is a big issue. The Equal Pay Act is tied to the Fair Labor Standards Act and requires equal pay for equal work regardless of sex already. So following that and remaining under that would be our where we would like to stay. In an issue with attorney's fees, this is actually a substantial shift, moving from prevailing, substantially prevailing versus totally prevailing is a big shift in how we would be doing things. And then the benefits and privileges is an expansion of it and a very hard way to actually determine whether or not someone is being compensated fairly, because that goes beyond just a number on a paycheck when you start to talk about benefits and privileges. For those reasons, we oppose the bill. Thank you.
Thank you very much. All right, ladies and gentlemen of the Committee on Reconsideration, Senate Bill 419 is before you, Senator Newman.
Mr. Chairman, first, when I read over this bill, it looked like a message bill, and I like the message, right? So, but the problem is reading the bill, and when you get into the attorney's fees, it looks like that was purposeful, and it is a substantial change. I think that we need others to look at that, so I would move that the bill be carried over to next year.
Mr. Chairman.
Second.
Mr. Chairman, over here. I know I'm the new guy on the committee, if I could just speak to that.
I'm waiting for a second.
Second.
Senator Stewart is a newbie.
Thank you, Mr. Chairman. Mr. Chairman, I voted for this yesterday, and then I was the one who went back and looked at it and realized I had missed a very important provision in it. And so while I supported the concept of equal pay as expressed in the bill, the other parts concerned me, and that's why I reconsidered the vote, and I wanted to explain that to the gentlelady. The litigation aspect of it gives me a great deal of concern. That's what I do for a living, and I know the mischief that can be caused by that. So with that, I hope we'd support the motion.
Thank you, Stuart. Any other comments? I think the concept is universally supported on equal pay and equal consideration, but this bill does have some nuances in it that are not quite so subtle. So the motion that's been made and seconded is to carry Senate Bill 419 over. Is there any discussion? If not, all those, open the roll, please, sir. All right, if you'd report the vote, please.
Ayes 11, noes 5.
Ayes 11, no 5, that the bill is carried over. Thank you very much, Senator Watson, for coming back. I believe you also have Senate Bill 426, ma'am.
I do, Mr. Chairman, and there should be a substitute for that.
Okay. Senator Hanger moves and Senator Newman seconds the adoption of the substitute. All those in favor, please signify by saying aye. Aye, and the substitute is adopted. Yes, ma'am, if you would be so generous to tell us what your
Thank you, Mr. Chairman, members of the
substitute, let me
committee.
finish, what the substitute does that the original bill did not do.
What the substitute does that the original bill did not do is that it takes the mandate to compile a new resource by the Domestic and Sexual Violence Advisory Council. It takes that mandate away and instead uses resources that we already have here in the state and deploys them more effectively and efficiently. So what it provides is that upon the issuance of these protective orders, the court will make available resources that we already have from the Department of Criminal Justice Services. Okay, so I think we can all start from the same shared premises that we want to make sure that domestic violence victims have access to resources in their time of need. Turns out there are a lot of resources out there, but they're not necessarily being deployed in the most efficient and effective way. And I think we can also agree that victims are most vulnerable at the time that they first obtain or when they obtain these protective orders. Now, there was concern in the courts committee, and I know that there's been concern that the advisory council was not the best group to be compiling these resources, or it was too much of a burden on them, or that this was already happening. And I've taken those concerns to heart, and that's how I have come up with this substitute here today. Which I think helps address those issues. So it turns out that DCJS does already compile resources, and they're available. There are a couple that are very good. There's a protective orders guide, a guide for victims in Virginia, which comes in English and in Spanish, and another informational guide for victims of domestic violence in Virginia is Understanding the Legal Process, and both of those have access to other resources and other places that victims can go, information included in those guides. So those are, but those are not distributed through the courts or made available at the court level. Instead, they are distributed through victim witness providers, but not every locality has one. So this substitute calls for these resources to be made available at the court level as well. And that way, they'll be able to get into the hands of as many victims as possible. Because there's not always victim witness involved or a police advocate or anything like that involved at the time that these protective orders are issued.
If I may interrupt you, has there been any ability to determine whether or not there is any fiscal impact on a state or a local level to come into compliance with the aspirations of this bill?
Mr. Chairman, there was a fiscal impact prepared for the previous version, but with the substitute, I don't think a fiscal analysis has been made. I can certainly represent to you and to the committee that these resources are already being printed and out there, and I don't know that it would be much more of an impact. I think we have somebody from DCJS here, or at least there was supposed to be somebody.
He's over your
here.
right shoulder.
Here we go. There you are.
Good morning, Mr. Chairman. My name is Thomas Fitzpatrick at DCJS. We already produced these brochures here. They are used and funded from some of our grants and some of our admin funds that we use as we support victims of crime throughout Virginia. So these are already produced brochures, and they are updated when laws change or as contact information does change.
All right, thank you very much, sir. Anyone else want to speak in favor of the bill? Anyone who has a different opinion on it?
Mr. Chairman?
Senator McDougal.
Mr. Chairman, I have a question, and when we were in, this is not specifically financial, but maybe. When we were in courts committee, the big concern I had about the original language is these are parties, preliminary protective hearing, even if it's granted, there are two potential parties that are in front of the court. And in this, we're saying the court shall make available to the petitioner to one party. I am very much in favor, having prosecuted a number of domestic violence cases in my previous life, of making sure that these resources are available to individuals. But I do have some concern. The court is the one supposed to hear the case, be a non-biased adjudicator of the facts, but we're telling the court to provide, in essence, make a showing on one side. Would it not be better if we required DCJS to place all these the publications that they're producing in each clerk's office around the Commonwealth instead of putting it on the court? Shouldn't it be, that's the part I have, is requiring a judge, meaning the court, meaning the judge, to provide this. I'd be much more in favor of DCJS being required to provide these in clerk's offices.
DCJS seems to want to share something with us.
Thank you, Mr. Chairman. Just a clarification or question. We are happy to provide the documents to anyone who requests them, but the onus of us placing them in the clerk's office may be a little bit challenging, but if we are able to provide them to the Office of the Executive Secretary or to other means, that'd be then easy. But if the request is for us to deliver them to each clerk's office, I just need to get a little more
So
clarification.
you're
on what the
supportive
request
as
is.
long as it doesn't put additional responsibilities on your agency?
But we will produce as many as we need, and that's easy.
Got it.
Mr. Chairman.
All right, any further questions? All right, ladies and gentlemen, the bill is before you.
Mr. Chairman.
Excuse me, Senator Newman, yes, sir.
I mean, I think it looks like a pretty good bill. I think we still have a fiscal impact. We don't know if he's going to pay or locality's going to pay, but I would put the clause on the bill, Mr. Chairman, then we can figure that out in the budget.
Okay. It's been moved and seconded that the contingency financial clause be put on Senate Bill 426. Any discussion? Hearing none, all in favor signify by saying aye. Aye. All those opposed, and the contingency financial clause is put on the.
Mr. Chairman.
It's been
Mr.
moved
Chairman.
and seconded that Senate Bill 426 as amended be reported. If you would open the roll, sir.
Roll is open.
Report the roll, please.
Ayes 13, noes 2.
Ayes 13, no 2. The bill is reported. Thank you, Senator Wexton.
Thank you, Mr. Chairman.
You have a nice morning. Senator Chafin.
Morning, Mr. Chairman, members of the committee. I have Senate Bill 448.
Senate
before
Bill
you.
448. Yes, sir. The abandoned schools and revitalization.
Revitalization zones. It's an idea that we came up with, Mr. Chairman, regarding school consolidation, which has been going around my district throughout, and especially in the Coalfield region where we have had such an economic struggle of late. So the concept here gives the localities the authority to adopt by ordinance the establishment of revitalization zones, offering local incentives such as reducing permitting fees, user fees, offering tax reductions, and aid in the sale of the property.
Mr. Chairman, I'm sorry, I've been looking for you. I haven't had a chance to talk to you,
Yes, sir.
Senator Chafin, but I would like to propose an amendment. There are some municipal broadband authorities that do reach into these areas that you're trying to do, and I would like to, on line 153, after broadband service providers, just add or municipal broadband
Senator Wagner,
authorities.
maybe a different bill.
Oh, I'm sorry.
That's all right.
That's the next bill.
Yeah, but you're all prepped for it, okay? All right.
Senator Wagner, you're always a man of great vision, and we have
Absolutely,
hired
and
that for you.
I'm looking into that crystal
I
ball.
want to thank
Mr.
you, but there is a line amendment that Lisa has. If you would be kind enough to report that, please.
Mr. Chairman, there's a technical amendment on line 20 after "of" at the beginning of the line, insert "local." This just makes it clear that the incentives that may be given are reductions of any other type of local tax.
So moved.
Senator Hanger moves and Senator Howell seconds the technical amendment. All those in favor of adopting that amendment signify by saying aye. Aye. All those opposed, and that amendment is adopted. Anyone who wants to speak in favor of the bill?
Mr. Chairman, before we go into
Sure,
that,
Senator Ruff.
if this is good policy, why not make it statewide?
Mr. Chairman, I have actually had some conversation with at least one delegate about a particular area that is in your neck of the woods, Senator Ruff. And so I certainly am not opposed to broadening the bill. I think the bill is good policy. I think there are abandoned schools that have been shuttered. They're still probably spending monies on upkeep and anything that could incent location of industry, jobs, and use those shuttered properties is probably good policy.
All right, well, let's see what this young lady has to offer. She seems very anxious to share with us, and we would like to hear from you. Thank you.
Good morning, Mr. Chairman. Liz Rafferty with the Department of Housing and Community Development, and we support this bill as it just provides the Coalfield region or any of the regions an opportunity to take these closed schools and convert them into revitalized properties that will present good economic development opportunities for the Commonwealth.
Thank you for being here. All right, ladies and gentlemen, the
Mr.
bill
Chairman.
is before you.
Mr. Chairman,
Senator Ruff, yes,
if it's
sir.
agreeable with the patron, I would move that we make this statewide rather than just those localities.
Is there a second to the amendment in concept to make it statewide?
Second.
It's been moved and seconded that Senate Bill 448 be enlarged to be a statewide application. Is there any discussion? If not, all those in favor of adopting that amendment, making it statewide, signify by saying aye. All those opposed? And that amendment is adopted. Ladies and gentlemen, the bill is before you as amended. It's been moved and seconded that Senate Bill 448 as amended be reported. All those, open the roll, please, sir.
Roll is open.
If you report the vote, please.
Ayes 15, noes 0.
All right, that bill is reported as amended. Chafin, Senator Chafin, you got another bad bill?
I do. I have another equally bad bill, Mr. Chairman. Senate Bill 857. We came up with this bill recognizing the divide between rural and urban areas with regard to a growing gap in broadband access. And so we were looking for a way to try to increase broadband access there in rural areas. My bill focuses on the the payments that communication companies pay for public right-of-way fees. So that's where a lot of this broadband is located anyway, is along those public right-of-ways. And so what this bill does, it aims to use half of those funds for rural broadband projects by directing the revenues to localities. That's going to account, and what it focuses on, the new revenue to localities is for 30%, those that are at least 30% unserved, to aid them in reaching public-private partnerships to roll out broadband opportunities. This is not enough for them to create their own broadband, but they could work in private-public partnerships with broadband companies to push it out into those unserved areas. So that's the concept of the bill. We think this would achieve only about $5 million. It's not going to be enough to fix the problem, but it's certainly an additional effort at solving the broadband divide.
Any member of the committee have any questions of Senator Chafin regarding 857? Anyone who would like to speak in favor of the bill? Anyone who'd like to speak in opposition to the bill? All right, step up. How are you this morning?
Good morning, Mr. Chairman. I'm doing well, thank you.
That's
Joe
good.
Lurch with the Virginia Association of Counties, and I want to thank the patron for reaching out to us with this concept early and having this discussion. And I can say that we do support incentives for increasing broadband access. However, our concerns with the bill are related to the amount of taking 50% of the 100% of the funds that VDOT collects and puts that back into construction for the secondary system. So that's just our concern with the bill. Thank you.
Thank you. Anyone else that would like to comment on it? I'm
Yes,
sorry,
sir, Mr.
sir, who are
Chairman.
you?
I often wonder early in the morning about that. Neil Minks, representing the Virginia Municipal League. We oppose this bill in its current form. Under the bill, it would direct those revenues that some 30-odd cities have enacted by ordinance, collecting these right-of-way fees that currently go for transportation, for maintenance of roads, and also go for our priorities of education and law enforcement. And we're quite unsure whether we have the capability of measuring whether that 70% rate that's in the bill of achieving broadband access, how we would determine that. Thank you, sir.
Anyone else who'd like to comment on it? If not, ladies and gentlemen, Senate Bill 857 as amended is before you.
Mr. Chairman.
You have an amendment, sir?
I do, Mr. Chairman. Line 153, if we're going to move forward with this, in addition to the private service providers, there are municipal broadband authorities that do reach into these rural areas, underserved. Botetourt County comes to mind, that kind of thing. So I would propose an amendment right after providers on line 153 to insert or municipal broadband authorities.
Is there a second?
Second.
It's been moved and seconded that the amendment in concept as reported by Senator Wagner, which would include municipal broadband authorities, be inserted in there. Is there any discussion? If not, all in favor of adopting that amendment, please signify by saying aye.
Aye.
Aye. All those opposed?
Mr. Chairman.
And it passes 2-0.
May I have a couple of moments to close with this bill?
Yes, sir.
Thank you. Mr. Chairman, just as we heard the other day with Senator McDougal's bill, we heard in Commerce and Labor, we heard the Virginia Municipal League and others oppose a bill that dealt with attachments, with trying to make it easier to get attachments into underserved areas. So we have a divide here, and that divide is growing because no one seems to get on the same page as to how to pull it all together and how to make it happen. So this is a bill that checks everyone's temperature on where their priorities are and what is actually of growing importance.
Thank you very much. Senator Newman.
Mr. Chairman, I apologize to the committee, and they may not want to do this, but I'd like for the bill to go by for the day. And here's why. I don't think those people that don't get the money are probably going to vote no, and the people who do may vote yes. And I'm just wondering whether or not we can't look at a way to incent people to go into these areas and let them keep part of the fees that would be added on top of it. So, Mr. Chairman, I just wonder if the committee would allow it to go by for the day.
Without objection, Senate Bill 448 as amended will be, excuse me, I apologize, 857 as amended will be passed by for the day. Thank you very much for your patience. All right, Senator McDougal, could I impose upon you, sir, perhaps to make a public safety subcommittee report, which, ladies and gentlemen, would...
Mr. Chairman?
What? We don't have them? Okay. It says on my calendar. Okay. All right, Senator McDougal, we are going to hold you in abeyance just for a moment, please, sir.
You ready for me?
Absolutely, sir.
Mr. Chairman, having voted on the prevailing side by which we reported Senate Bill 425, I move that we reconsider that vote.
It's been moved and seconded that we reconsider the vote by which we reported Senate Bill 425. All those in favor signify by saying aye.
Aye.
All those opposed, and the bill is reconsidered.
Mr. Chairman, that's Senator Wexton's bill, the
426?
426. I'm sorry. What he said. Mr. Chairman, do I need to remake that motion, or are we good?
We're good. 426, we got it.
All right, Mr. Chairman, and I'm going to defer to Senator McDougal in a second, but what concerns me, and I mean no harm to the bill, I voted for it and I'll vote for it again, but upon reflection, I think Senator McDougal makes a very good point concerning the court being charged with the dissemination of these materials. The DCJS representative pointed out in his testimony that he didn't want to be charged with the responsibility for getting this material to the clerk's office, which leads me to wonder how is it going to get to the courts. So I think that maybe Senator McDougal has a concept in mind as to how this might be amended so that that concern can be addressed. I share Senator McDougal's concerns about the court being charged with that responsibility, and upon hearing DCJS testimony, I'm afraid that that burden is going to fall on the court, and that they're going to deliver it to the to 9th Street, to the Office of the Executive Secretary, and somebody's got to get it out. So I do believe that an amendment would be appropriate. I yield to Senator McDougal.
Senator McDougal, you've been yielded to.
Mr. Chairman, I voted against it because of the requirement of the court to provide the information. I do think the information is very important that we get to the citizens who are subject to some sort of domestic violence. So, Mr. Chairman, I would move that
All
we
right, if I
change.
could interrupt you just a moment, and my anxiety to move things along, it's been moved and seconded that we reconsider the vote by which the bill 426, which actually requires a recorded vote. So if you would open the roll, please, sir. If you would report the vote, please, sir.
Ayes 14, no 0.
The bill is now formally reconsidered, and Senator Obenchain, thank you for your comments, and Senator McDougal.
Mr. Chairman, I would move that that section that I think is repeated in multiple places be that the Department of Criminal Justice Services shall provide to each general district, juvenile and domestic relations district, and circuit court clerk's office information to be displayed publicly regarding resources for domestic violence victims.
Second.
Did council in concept get the amendment, proposed amendment? You did. All right, it's been moved and seconded that the amendment as articulated conceptually be adopted. Senator Donovan. Yes, ma'am.
Mr. Chairman, I think the intent of the bill is that the individual that has just received the protection order is actually given the information. And I think this is important. This is an individual that's fragile at that time. If they're supposed to pull out of a kiosk the papers, that's a little different. I think it changes the intent of the bill, and the patron's not here. I think it should, if you want to have somebody other than the judge give the documentation, I think that's fine. It just needs to actually be given.
Mr. Chairman.
Senator McDougal.
Mr. Chairman, the issue is that individual will have to go to the clerk's office. If the clerk, if you want to have the language say, which will be provided by the clerk, that's different than the trier of the
Yes, I
fact
prefer
providing
that.
that. So
are you modifying your amendment?
Modifying the order, because, Mr. Chairman, logistically, the petitioner will go to the clerk's office to receive the copy of the protective order that the judge has just entered, so that will create no additional burden to the clerk, because they're already having to provide them the actual order issued by the judge, because that's typically not provided from the judge directly to the petitioner.
All right, well, let's see if Lisa has captured that, at least in concept.
Mr. Chairman, so I think in light of Senator Donovan's comments, the amendment would just be in the various places to replace, instead of the court shall make available, the clerk shall provide the petitioner with the information published by DCJS upon issuance of the protective order.
Okay. Senator Donovan and Obenchain and McDougal, does that capture your sense?
Second.
All right, so it's been moved and seconded that the amendment in concept as just articulated by Lisa be adopted. Is any discussion? All those in favor, please signify by saying aye. Aye. And that amendment is adopted.
Move to report
As amended.
It's been moved and seconded that Senate Bill 426 be reported as amended. All those in favor signify, report by the board.
Roll is open.
If you would report the vote, please, sir.
Ayes 13, no 0.
Ayes 13, no 0. The bill is reported. All right, are we good on the vote?
Yeah, we're good.
All right, the bill is reported a second time. All right, everybody's getting Ladies and gentlemen, we always like to accommodate Senator Servell, and he's graciously communicated to the chair that he would like to strike Senate Bill 618. So Senator Hanger moves and Senator Newman seconds that Senate Bill 618 be stricken. Open the roll.
Roll is open.
Report the vote.
Ayes 16-0.
The bill is stricken. So with that, we have completed all of the non-Senate Finance Committee members. And Senator McDougal, I am now advised that we are prepared to go forward on the Public Safety Subcommittee report. And once again, ladies and gentlemen, that would be purple in your pile of paperwork. Blue. Oh, blue.
Thank you, Mr. Chairman. We'll take a couple, if we can do Senate Bill 715 first. Subcommittee reviewed 715, determined it had no physical impact, and moved to report 6-0. And I'd so move. 715.
Moved and
Roll is open. Ayes 15. What?
Green. Where's Hal?
Okay.
All right, roll is open. Ayes 10.
Close the roll.
5.
All right, that bill is reported. Senator McDougal.
Mr. Chairman, there were two bills that dealt with Woodrum fiscal impacts. We had taken up most of the Woodrum impact bills last week. Committee has had a longstanding determination that we are focusing our limited resources in challenging economic times as far as state budgets toward existing obligations like our state police and sheriffs. And with that, Mr. Chairman, subcommittee recommended that Senate Bill 952 and 541, because of the Woodrum impacts, be carried over for the year.
Is there a second? Second. It's been moved and seconded that Senate Bills 952 and 541 be carried over. Any discussion? If not, open the roll, please.
Roll is open.
Report the vote, please.
Ayes 14, noes 1.
Ayes 14, no one. Those bills are reluctantly carried over.
Senator Stewart didn't like our decisions, but he didn't come to try to persuade us earlier either. Mr. Chairman, there were two other bills that were in a similar position. Senate Bill 48, Senator Black's bill, and Senate Bill 350, Senator Peak's bill. These both conceptually came to us, and there were a lot of positives about the concepts, but in both of these, there were one more, Senator Black's more so than Senator Peak's, but both had substantial physical impacts, and the subcommittee recommended that they be carried over, not because of their concept, but because of the negative physical impact to the budget, and I would so move.
Is there a second? Second. It's been moved and seconded that Senate Bill 48 and Senate Bill 350 be carried over. Is there any discussion? If not, note your vote on the board, please.
Roll is open.
Report the vote, please.
Ayes 13, noes 2.
Ayes 13, no 2. Senate Bills 48 and 350 are carried over.
Mr. Chairman, Senate Bill 402, which was my bill dealing with restricted driver's license for individuals convicted of a DUI, added a additional alcohol monitoring device to a person and open up the restrictions. There's a substitute that eliminates the physical impact. And I would so move the substitute. We reviewed it in subcommittee, but I don't know if we physically have it right in front of us.
I'm sorry, Mr. Chairman, Charles didn't get, do you want me to describe it or do you want me to turn it down?
I'm sorry?
Charles didn't get the substitute.
You want me to come back to that, Mr. Chairman?
Yeah, if we could temporarily
Okay.
pass that bill,
We'll move
please, sir.
on to do you have the others in, okay, Mr. Chairman, then there was Senate Bill 334, Senator Peake, Senate Bill 403, which was my bill, and Mr. Chairman, there was your bill, Senate Bill 954. Each of those bills dealt with expungements of different items, but some overlapping, but none inconsistent. Mr. Chairman, Senate Bill 334 dealt with expungements of possession of alcohol offenses. Senate Bill 402 dealt with expungements of possession of alcohol. 403 dealt with expungements of possession of alcohol and possession of marijuana if you're under the age of 21. And Mr. Chairman, your bill changed the penalty for marijuana and dealt with expungements of marijuana. As the subcommittee discussed this, we thought that the financing of each of those bills should be the same. And so a substitute was prepared for each of those, and I would move the substitute in all three of those bills. So they're consistent.
Is there a second? It's been moved and seconded that a substitute to each of those bills be adopted. Is there any discussion? If not, all those in favor of adopting the substitute, please signify by saying aye.
Aye.
Aye. And all those opposed, and the substitutes are adopted. Senator McDougal.
Mr. Chairman, so what the substitute that the members have before them do two things. One, on the expungement fee that you pay to the clerk's office. Today, if you provide that fee to the clerk's office, your case is expunged, that fee is returned to you. This says, because we're saying because these items, you were either convicted or the court found the facts were sufficient, that fee is not going to be returned to you. It's going to be used for the processing of these expungements. And Mr. Chairman, the concept that you had in your bill 954 of setting up an additional $300 fee that would go to an opioid fund, we took that fee and put $150 to the state police to offset their administrative cost in doing these expungements and $150 to that fee. And we made each of the bills consistent so that if they all go through, there's no inconsistency, or if one or two of them make it through, there's still consistency. So I would move all three of these bills be agreed to.
Is there a second? It's been moved and seconded that Senate Bill 334, Senate Bill 402, and Senate 954, all amendments in the nature of the substitute be reported. Any discussion? If not, all those in favor signify by saying aye. Aye. Oh, excuse me, the board.
Roll is open.
Report the vote.
16, no 0.
Those three bills are reported. Senator McDougal.
Mr. Chairman, then we had Senate Bill 565, which was Senator Obenshain's bill. This was a bill that came out of the Crime Commission. So we looked at the bill. It could have some substantive cost. We did not have a lengthy discussion at all about the substance, but with that cost, the subcommittee recommended that we put the clause on the bill, and I would so move the clause.
Is there a second? It's been moved and seconded that the financial contingency clause be attached to Senate Bill 565. All in favor signify by saying aye. Aye. All those opposed, and the clause is adopted.
And, Mr. Chairman, the subcommittee recommended reporting the bill with the clause, and I think I was the lone dissent because I am not in favor of adding additional misdemeanors to the DNA database, but I would so move that the bill be reported with the clause.
Is there a second? Second. It's been moved and seconded that Senate Bill 565 as amended be reported. and 644 as well.
Mr. Chairman, I was going to do 644 differently because it's a little different concept. And I want to, but it'll still need the clause when we get there.
As I originally stated, Senate Bill 565 as amended is before you. If you'd report your votes, please.
Vote is open.
Report the vote, please.
That's 15 noes, 1.
The bill is reported. Senator McDougal.
Mr. Chairman, then you had Senate Bill 664. This also deals with a DNA sample taken in a criminal offense, but this one is different from 565 because this is a sample taken at the time of arrest for a misdemeanor. So these would be the first misdemeanors that we take samples at the time of arrest. Right now, we take samples at the time of arrest for violent felonies and breaking and entering, which we've determined to be a violent felony. So rape, robbery, murder, arson, most of the sexual offense cases, malicious wounding, there's the specific list in the code. This adds misdemeanors. There is a physical impact, so it would take the clause. So I would move the clause be added to 664.
Is there a second? It's been moved and seconded that the financial contingency clause be affixed to Senate Bill 644. All in favor signify by saying aye. Aye. All those opposed, and the clause is attached.
Mr. Chairman, as I think I previously stated, I personally am not in favor of taking a DNA sample for a misdemeanor, and particularly a misdemeanor at the time of the arrest, but the subcommittee moved to recommend reporting, and I would so move with the clause.
Is there a second? There's a muted second. It's been moved and seconded that Senate Bill 644 with the amendment be reported. Please note your vote on the board.
Roll is open.
Report the vote, please, sir.
Ayes 12, noes 4.
Bill is reported as amended. Senator McDougal.
Mr. Chairman, we had one other bill in addition to the one we don't have the substitute. That was Senator Stanley's Bill 173, dealing with fireworks regulation. In essence, Mr. Chairman, it would make Class A fireworks the ability for locality to determine whether to sell them or not at a brick and mortar facility. And through that, there would be a 7% fee or fund fee, I think is what they referred to it as, added on to each sale, returnable to the local sheriff's departments in the jurisdictions that approved the sale of these, but it is a jurisdiction by jurisdiction determination of whether to sell these Class A fireworks. Mr. Chairman, we had, I think there had been substantive debate in committee before it was referred to us. We had presentations from both those for and against it. And after that presentation and a zealous advocacy by Senator Stanley, we voted on a very bipartisan direction, 3-3, and it was equally bipartisan. Same number of Republicans and Democrats liked it. Same number of Republicans and Democrats did not like it. So with that, Mr. Chairman, it's before you.
You have a motion, sir?
I'd move to gently carry it over for the year.
Is there a second? It's been moved and seconded that Senate Bill 173 be gently carried over for the year. If you'd open the roll, all those in favor vote aye. All those against, nay.
Roll is open.
If you report the vote, please.
Ayes 11, noes 5.
11-5, the bill is gently, Senator Stanley, carried over for the year. And thank you for your advocacy, sir. Senator McDougal.
Mr. Chairman, that leaves us with Senate Bill 402. We don't, again, the subcommittee heard this, that we made a unanimous recommendation to report the substitute, but its substitute's not down, it's coming, so if you
Well, we'll
want
move
to come back
along
to it.
then, and maybe we'll have to come back to 402.
Mr. Chairman.
Senator Hanger, yes, sir.
Mr. Chairman, I just, with Senator McDougal submitting his report, I just wanted to make an observation. Last week, Senator McDougal made his report, and there were a couple controversial bills in that report. but they were, a couple that were PBI'd were pulled out and voted on individually. The clarification I want to make, I saw a report where one of those controversial bills was reported was killed in subcommittee. And I just want to remind everybody that we don't do that, that all bills are brought here with recommendation, and then we get a recorded vote here in the full committee. Mr. Chairman, thank you.
Mr. Chairman, it looks like Charles has, we now have the substitute to 402. So with Senator Hanger's filibuster, we were able to get to the bill. Thank you, Senator Hanger. You did a great job.
Well done, sir. All right, Senator McDougal, back to Senate Bill 402.
Mr. Chairman, I move that the subcommittee heard this. There was 2 amendments that were made to the original bill that are encompassed in the substitute. One clarifying that this only applies to an individual who's never previously been prohibited from having a license as a result of driving under the influence offense, and a second which makes it clear that a violation of the additional monitoring device is a new misdemeanor violation, not in the list that could be added on that would ultimately become a felony, which we commonly know as a 18-2-272 violation. So with that, Mr. Chairman, we had a report from JLARC and that there was no physical impact in the committee recommended reporting, and so I'd move that we adopt the substitute, and then I'll have a motion to report.
Is there a second to adopt the substitute to Senate Bill 402? All in favor signify by saying aye. Aye. All those opposed, substitute is adopted. Senator McDougal.
Mr. Chairman, I'd move that we adopt or that we report the bill in the nature of substitute.
Second. Been moved and seconded that Senate Bill 402, amendment in the nature of substitute, be reported. If you would please note your vote on the board.
Roll is open.
Report the vote, sir.
Ayes 16, no zero.
Ayes 16, no zero. The bill is reported. Does that complete your report, Senator?
It does, Mr. Chairman. I want to thank the members of the subcommittee. We always have a, as I articulate, very difficult challenge, and we have a great subcommittee, and I'm very appreciative for each of their efforts.
All right. With that gratitude, I'll call on my co-chairman, Senator Hanger, has 3 bills, I believe, sir. Good morning, sir.
Good morning. Thank you, Mr. Chairman. I'll call Senate Bill 537 first, Mr. Chairman.
Senate Bill 537, if you direct your attention to that, please.
Senate Bill 537 was requested by a number of entities, including VACO, a number of the counties, the Rappahannock River Basin Commission. And what it does is propose to make an adjustment to the composite index based on the actual values of land under land use as opposed to market value. Staff, Sarah did quite a job of putting this together, and we discovered that if we were to pursue this bill right now, 67 localities would win, 68 localities would lose. And it was my determination, I think it would be your feeling as well, that this issue is something that we need to get all the facts on the table at a time where we probably could hold harmless those that might be losing if we were going to adopt such a policy. So, Mr. Chairman, I would ask and I would move that the bill be continued to the 2019 session.
Is there a second? It's been moved and seconded that Senate, excuse me, that Senate Bill 537 be carried over for the year. Any discussion? If not, all in favor signify by saying aye. Aye.
Aye.
Up, the roll is open. Sorry. You got to keep your eye on me, John. Report the roll.
Ayes 16, no zero.
Ayes 16, no zeros. Your next bills.
Thank you, Mr. Chairman. It would be my intent to try to explore some of that standards of quality and what have you in our fiscal stress joint subcommittee.
I expect there's a lot of room for exploration there.
Right. Senate Bill 656, Mr. Chairman, members of the committee.
Senate Bill 656, ladies and gentlemen, is on the purple sheet.
Thank you. Mr. Chairman, this deals with Virginia 529. Most of the members are familiar with this initiative now since it's come through the Education Committee and was referred here for potential fiscal impact. I do have a number of talking points. I may just ask the officials from the 529 program to make a brief comment about where this takes them rather than me going through my litany here. Mr. Chairman.
Mr. Chairman, I would say I expect that some of us would be particularly interested in whether or not your approach is a major change in the policy direction of 529.
Okay.
So
the policy having been settled, I guess it comes down to a question on the fiscal impact. The fiscal impact would be in making these changes, which have been well vetted over a 3-year period, which will, I think, provide a flexible, much improved product for the Commonwealth, is that a portion of their work would then be taken out of the Cardinal system. The fiscal impact statement that we have assumes that all of it would come out. I have revised numbers here which indicate that only the distribution of checks, or it's a small percentage, 25%, would come out of the Cardinal system. And what it does in terms of fiscal impact is leave stranded costs, because the Cardinal system is supported by all the participants. And then when someone ceases to participate, then you recognize that when you divide the number of participants into the lump sum, then everybody has to pay a little more. So it's been expressed to me, and I believe that is the fact that it would be a very minor fiscal impact, Mr. Chairman.
Okay. All right, Mary, you have any comments you want to share?
Sure. Just on the fiscal impact part of it, that's absolutely correct. What we're asking for is to authorize a decentralized disbursement system for.
But aren't you going from selling like semesters to units?
Yes, so I wasn't sure where your question lied. On the policy of it, yes. It is a significant change.
Listen to me, please.
Okay, I'm sorry.
Help me how that change from going from semesters to units impacts the 529 program.
Sure. It's a change in the benefit structure to the prepaid program. There are a number of things in the bill, and that's why I wasn't sure what the question was. On the fiscal impact, doesn't really go to that part of it. But you're right, it is a significant change to the benefit structure of the prepaid program. We've spent about 3 years studying this at Virginia 529, gone through it with our board, worked with our actuary to look at what's the best program for the future. About 5 years ago, we went from years that we sold to semesters. That helped. That increased the numbers that could participate. We cut in half about the cost of getting started. So right now, the minimum commitment that someone has to make to the prepaid program is just under $9,000. That's the cost of a single semester's contract. You can pay for that over time. There's a fee that's included on top of that because we don't have the use of those funds to invest during the entire time. So you have a contract, you have to make a payment every month. So when
Talk to me about this weighted average.
Sure. So what we're looking at instead is a program where you would have units. 100 units would equal 1 year of tuition. And what we look at, rather than covering the program we've had for the last 21 years, if you make a payment, you buy a contract, whether it's for a year, a semester, whatever it is, the promise is that that will cover full tuition and mandatory fees at any Virginia public university in the future when it's used. Right now, the disparity in the cost in the Virginia's universities is at a high of about $23,000, a low of just under $9,000. So for the same contract, that's sort of the disparity in payments from the program just to Virginia public schools. There's a different payment structure if you go to a Virginia private school. That's pretty complicated. It's the lesser of two different amounts. And again, if you go to a school out of state, it's a different payment yet, the lesser of two different amounts, with the lowest being essentially what you've paid in plus a reasonable return. That reasonable return is based on the institutional money market amount, which has been very close to zero for almost the last 10 years. There's just a broad dispersion of costs. So when we looked at how people use education, the growing disparity in pricing in Virginia's universities, the different tuition and fee models. Another challenge for a sort of one-size-fits-all program is that some universities charge a set rate for a set number of units. Usually it's 12 to 18 credits. There are a few schools where they cover 12 to 17 and a few schools that cover 12 to 16 units. Others, and VCU is one that just a few years ago went to a credit hour. So they charge by the credit hour that the students take. If they take at least 12 hours, they have used an entire semester of their prepaid contract, even though it actually would have covered more. So there's a lot of disparities there. So what we look at with weighted average, what we're saying, if this would go through, the new program, you would purchase units,
as low as 1 unit. We don't know what the pricing would be. I'm going to guess by the time we would open something just under or around $200. That would be the minimum point where people could get started. You could buy up to 700 units in the way we have it formulated right now. So you could, in fact, cover full tuition and mandatory fees. You would just need more than 400 units, because the plan would be, or the proposal is, that that unit would be based on a percentage of the weighted average tuition at a Virginia university. Right now, this year, that's about $12,200. So it's a different defined benefit. It still becomes a defined benefit program. All the other aspects of the program would remain unchanged. So it would still be available just to Virginia residents. Either the account owner or the beneficiary would have to be a
Is there any
Virginia
potential
resident.
for shifting of cost to other state agencies with general funds?
No. I don't, I'm not sure I understand the question. I mean, you still.
I'm reading a bullet. Since Virginia 529 is funded by non-general funds, any shift in its cardinal's cost to other state agencies would create an indeterminate general fund impact.
I
Do you
believe.
agree or disagree with that?
Well, I disagree with that, except that I think that refers only to what is the amendment in section 23.1701D, which
It does.
relates to the disbursement account. So it doesn't have to do with the prepaid program, and that disbursement account is simply asking that we, it would allow us to make distributions faster, and with the new program, we would have more payments that could perhaps go to the individuals. Right now, all of our payments from the prepaid program have to go through the state treasury, so we can't do ACH payments, we can't do distributions as quickly as we can for our others. That's something similar that's been done with public universities already. They have decentralized disbursement accounts, and we already have that for our Invest 529 program. So I think the cost is on.
Okay, let me see if any
Cardinal's
member.
about $20,000.
Mary, let me see if any members have any
Okay.
specific questions. Does any member of this committee have any specific questions of Mary regarding this proposal? If not, Senator Hanger, do you have anyone who'd like to speak in favor of it other than Mary?
Just, not that I'm aware of, Mr. Chairman, this was, went through the Education Committee, Senator Saslaw Subcommittee vetted it. It makes some minor changes in the statute, but this, you're at the essence of what it does. There is the possibility, if there were a slight stranded cost, say 10, 15, even 20,000, that we could, nick the fund for that, because we do pull funds back to support the program as necessary. So I think
Let me
they
see
would
if
have
anyone
funds
has any opposition to it,
Right,
sir.
okay.
Is there anyone who would like to speak in opposition to the bill? All right. Any member of the committee have any further questions? I'm sorry, I didn't mean to cut you off, sir. Was there anything else you wanted to add?
I'm good, I'm good.
All right, ladies and gentlemen, you have Senate Bill 565 in front of you. Is there?
Chairman, I would certainly move the bill be reported.
It's been moved and seconded that Senate Bill 656 be reported. Any discussion? If not, if you would note your vote on the board, please.
Roll is open.
Report the vote, please.
Ayes 13, no 0, 1 abstention.
All right, the bill is reported. Senator
Thank you,
Hanger.
Mr. Chairman. And then quickly, Senate Bill 950, Mr. Chairman, we have a substitute that I would like to have distributed and
Senator
adopted.
Hanger moves and Senator Howell seconds the adoption of the substitute to the bill. All in favor signify by saying aye.
Aye.
All opposed, and the substitute is adopted. Yes, sir.
Thank you, Mr. Chairman. I consider this a fairly significant piece of legislation in that the stakeholders have been working on this for quite some time while we've been here, and just the print is still warm on this. What this does, Mr. Chairman, in the substitute, is designed to ensure that water quality is protected in local streams and downstream waters in connection with the construction of any future, and I would say future interstate natural gas pipelines greater than 3 feet in diameter that are regulated by the Federal Energy Regulatory Commission. The bill essentially builds on the experience with the ongoing regulatory process for the two that we have now that are working their way through, Mountain Valley Pipeline, Atlantic Coast Pipeline, but it would not apply to those pipelines. It would only apply to any projects applied for after July 1, 2018. The bill clarifies, and this was really the essence of where I was trying to get at, because I know our State Water Control Board and DEQ have struggled with the lack of objective standards for how they would proceed with these applications. But the bill clarifies the process by which DEQ and the State Water Control Board will determine whether Virginia will issue a certification required by Section 401 of the Clean Water Act that a proposed pipeline will not harm water quality. For these pipelines, the bill specifies that the 401 certification process will have two parts. First, the bill requires a detailed individual Virginia water protection permit to protect each wetland and stream proposed to be crossed by the pipeline. Second, the bill requires an evaluation of pipeline activities in upland areas not involve wetlands or stream crossings that may result in a discharge to state waters that could adversely affect water quality. The activities to be evaluated include land disturbances, trench digging, and related work. I will try to keep this brief, but it gets into all of the concerns of conservation issues, high water tables, karst geography, proximity to streams and wetlands. The bill also provides for the department's ability to recover its direct costs for services rendered through an administrative charge to the applicant, public notice and comment, and an opportunity to request a public hearing, clarification that the 401 certification decision could be made by either the board or DEQ. Mr. Chairman, there is one issue that was not resolved in this bill. The substitute bill was developed in part with input from a variety of stakeholders from industry, DEQ, and the conservation community. They made significant progress, and consensus is in the bill with one issue, and the reason that is not in there is litigation on a particular issue, and we're not addressing that in here. The question is to which the 401 certification decision must involve board evaluation of final and approved erosion sediment control plans and stormwater plans. The question there is in litigation and is not included in the bill. Otherwise, and I'm sure there would be people who speak to it if you want to hear from them, I think we have consensus other than that issue, and that's not in the bill.
Does any member of the committee have any questions of Senator Hanger on Senate Bill 950? If not, is there anyone who would like to speak very briefly in favor of the bill? Good morning.
Good morning, Mr. Chairman, members of the committee. I'm Peggy Sander from the Chesapeake Bay Foundation. Thank you for the opportunity to be here. Thanks very much to Senator Hanger for his work on this bill, his interest in the subject. I just want to clarify, the Bay Foundation is very grateful for the heart of the bill, which, as Senator Hanger said, is the portion that requires an individual Virginia water protection permit for essentially each of the major water crossings and wetlands crossings anytime a pipeline of this sort is considered. DEQ is very experienced in administering this work, and we think it's appropriate for it to continue to do so. I also wanted to emphasize, as Senator Hanger said, we are among the groups who are concerned about some issues not addressed here that may be addressed by the Fourth Circuit Court of Appeals. So our gratitude is fulsome. Our appreciation of the bill for what it says is strong, but there's lots more that's outstanding, and we just wanted to note that certain issues may come back before this body in the future. Thank you very much.
Thank you very much for being here. Anyone else that would like to speak briefly in favor of the bill?
Good morning, Mr. Chairman. My name is Peter Anderson. I'm with Appalachian Voices. We also want to echo Ms. Sanders' comments and appreciate what this bill is trying to accomplish here. We appreciate the addition of the VWP permit and the prevention of any Clean Water Act 401 waiver. Those are excellent changes in policy that we really appreciate. We do have one significant concern in the new Article 2.6 section regarding upland conditions. At line 188 of the substitute that I'm seeing, we are concerned about erosion and sediment control, stormwater plans, and karst plans.
Have you discussed that proposed change with Senator Hanger?
I personally have not, but I understand other stakeholders are. So
That's right. I think, Mr. Chairman, that's the essence of your concern is what Ms. Sander just shared, which is in litigation. So we're not addressing that.
That issue is a part of litigation. Sir, not with being abrupt, but we generally don't entertain issues pertaining to pending litigation.
Absolutely, and I appreciate
So
that.
otherwise,
Just-
do you support the bill?
We support the intent of the bill, and that's all. Thanks.
Yes,
Mr.
sir.
Chairman, Mike Town, Virginia League of Conservation Voters, we support the bill.
Thank you for your brevity. Yes, sir.
Mr. Chairman, Harrison Wallace with the Chesapeake Climate Action Network. We share the same concerns as that voices, but we do support the intent of the bill.
Thank you very much, sir. Mr. Lessner, you want to be heard? You came all the way down here? I know what an articulate spokesperson you are on this passionate issue. All right, welcome, sir. Senator Hager.
Thank you, Mr. Chairman. I think what you've heard is the general consensus from industry, those that would be involved in potentially in the future in building pipelines. We had a consensus. We could not address that one issue as it's been expressed here, that's subject of litigation, but I think we have a pretty good bill here to lay out a roadmap for these type of future projects for the DEQ and for the State Water Control Board.
Do you have a motion, sir?
Yes, Mr. Chairman, I'll move the bill be reported.
It's been moved and second that Senate Bill 950 be reported. Is there any discussion? Hearing none, if you'll open the rolls, sir. If you report the vote, please.
Ayes 14, noes 2.
The bill is reported 14-2.
Thank you,
Senator-
Mr. Chairman.
Senator Hanger. Senator Howell. You have Senate Bill 394, which is on the purple sheets.
Thank you, Mr. Chairman. This bill sets up a Office of Student Loan Ombudsman and gives sort of a Bill of Rights for student loan borrowers. The goal is to help our students and their families go through all the requirements of student loan borrowing and to make sure that they have somewhere they can go to get to get advice that's impartial. It has a slight fiscal impact. I guess that's why it's here.
Okay, Senator Howell, this, I think it does have a fiscal impact, but was included in the introduced bill. And I guess from abundance of caution as to how deeply we need to cut, we probably should put the clause on it. Does it already have it on it?
I don't believe it does, but it is, as you said, in the budget.
Okay, it is in the budget, so we should be able to do this, I hope, but I would, Chair would entertain a motion to add the clause.
So moved.
Motion properly supported. All those in favor signify by saying aye.
Aye.
Any opposed? All right. You have the bill in front of you. What's the pleasure of the committee? Motion properly supported to report Senate Bill 394 as amended. Clerk, open the roll.
Roll is open.
Record your votes.
Thank you.
Close the roll. The bill is reported 16-0. Thank you, Senator Howe.
Next is Senator McDougal, who has Senate Bill 823.
Thank you, Mr. Chairman. This is an excellent little bill that doesn't do anything but raise money for the Commonwealth. Mr. Chairman.
Okay, well, let's see how much you can raise, sir.
Mr. Chairman, this is 823 dealing with wireless support structures and establishing specific fees for those. Right now, is not a unified fee structure. What this bill would do is put in place an annual fee structure for use in public right-of-way, determine that fee structure based on the height of the structure that's in place. It is annual, and Mr. Chairman, it increases every 5 years with the Consumer Price Index, so we built a automatic escalator into the bill. And finally, Mr. Chairman, in the last paragraph of the bill, any agreements that are currently in place are allowed to continue to be in place going forward. So whatever deal was currently struck will continue to be struck, but this will put in a uniform system across the state, which I believe will ultimately add to more fees to the Commonwealth because it is a known system structure and is not individually negotiated.
Excuse me, any member of the committee have any questions of Senator McDougall on Senate Bill 823? Anyone who would like to speak in favor of Senate Bill 823? Good morning, sir. How are you?
Good morning, Mr. Chairman. Rick Cornwell with Verizon. These rates were mutually negotiated with VDOT. We're in agreement with them to bring them more in line with current technology and in the current marketplace, and we think it's a very good bill, and we support it. Thank you.
Thank you, Mark. Anyone else who wants to speak in favor of the bill? Anyone who'd like to speak in opposition? Yes, sir. Good morning.
Chair.
Come on up.
Mr. Chairman, Joe Lurch with the Virginia Association of Counties. In opposition, the one thing that we'll point out is that localities weren't a party to this agreement. Apparently, that was with VDOT. One thing that the patron said is that this wouldn't affect any existing agreements, particularly localities. But it says, if you look at on the line, it says until expiration of the current term of the agreement. So once those agreements are finished, then the localities would have to go by this rate schedule. I will say that, our public roads and rights-of-way have been enhanced through significant investment through construction and maintenance. What we've seen in other cities or other places across the U.S. are ones typical of what was done in the city of San Antonio, where it was actually not for a pole, but just for an attachment to a utility pole, where it's a 25-year agreement with a 3% annual escalation for $1,500 per one attachment, and it gets renegotiated every 5 years. We respectfully submit that localities that own and maintain their own right-of-ways should retain that ability to negotiate directly with the industry like we've been doing currently. Thank you.
All right, thank you very much, sir. Anyone else?
Thank you, Mr. Chairman. Again, Neil Menks, same name still, representing VML. I would just point out that last year's wireless bill, which dealt with existing structures, the provision of that law says that the negotiations for the right-of-way fees is between the providers and the localities. It puts a burden on the locality to prove that the rates that the locality wants are reasonably related to the actual and direct and are reasonable costs. And all we're asking is that that model for the existing structures be applied to the new as well, so we don't have two different systems. Thank you.
Thank you, Neil. Anyone else? Any member of the committee have any questions? Senator Barker.
Mr. Chair, Senator McDougall, on the write-up that we have here, it says that capping fees may impact current funding of approximately $5.2 million per year that is used for debt service on Northern Virginia Transportation District bonds. Can you,
Mr. Chairman,
respond on that?
I did see that right before I came down here. My belief is that lines 35 through 39, which says the existing fee structures are in place with an agreement, that those bonds would have to be based upon an agreement that's currently negotiated. And my guess is that I have not looked at the agreement, but I would find it hard to believe that somebody would have placed a bond on an agreement that was not for the length of term of the bond. But I do not know the specific answer to that.
Mr. Chairman.
Senator Sasslaw.
I would hope that you would appoint a subcommittee of one, Senator Barker, to inquire over the next 24 hours as to will this have an impact on these bonds. And, with that, and I would hope Senator McDougall agreed to let it go by for the day and take it up again tomorrow when we have more information.
Mr. Chairman, I have no objection to that.
Okay, thank you.
If certainly the intention is, and that was the reason the language was put in there in those final lines, to not impact things like Senator Barker articulated. So I think that we can probably find a solution if he finds otherwise.
Thank you for that courtesy. Without objection, it will pass by for the day, and the one-person exhaustive subcommittee of Barker will look into that. And while we're waiting, Senator Vogel has one bill, and so we'd like to hear from you on Senate Bill 899, please, ma'am.
Thank you, Mr. Chair and members of the committee. I have Senate Bill 899.
Senator Sasslaw moves and Senator Hanger seconds that the amendment in the nature of substitute to 899 be adopted. All those in favor signify by saying aye. Aye. And all those opposed, and that bill is before us. Good morning.
Good morning. Mr. Chair, this is not your typical conveyance bill. I wish that it were. I have worked diligently on behalf of Clark County to transfer a piece of property there that is a 200-acre parcel that they have wished to acquire for a campus there where they would like to provide social services, and more importantly, they have listed as their highest priority, and I would say if one of the supervisors were here, he would say to you, their highest priority, they said, is the establishment of an inpatient drug facility and treatment location. At this property, it was formerly a correctional facility. And so some time ago, we set out with DGS, the Department of Corrections, to transfer this property. Where we are now is we are not seeking to transfer the entire 200 acres. We're not even trying to convey it. All I have in front of you today is hold it. Hold it. We're not even asking for the whole 200 acres anymore. It's down to 65 acres. So what we're seeking to have the legislature do is assist me in having DGS hold this, to not transfer it or sell it to anybody else during the pendency of the time the Department of General Services is engaging in a negotiation for the sale of that
How
property.
long do you want us to hold it?
Well, I'll be honest with you, I'd like you to convey it. But right now, I'm just asking that
Do
it
you
be
want us to hold
held.
it until July of 2019?
Yes.
That's
Thank you. That's all I want you to do.
That is a splendid year. You know, we're gonna
Isn't that a great year?
A great commemoration. It'll be this conveyance
Thank you.
bill.
Right.
As well
I'm
as
just
what
asking
happened
you
in
to
Jamestown.
help Clark County.
All
How about
right.
that? Thank you, Mr. Chair.
Any member of the committee have any questions? Anybody wants to speak in favor of the bill? Anyone that wants to speak in opposition to the bill?
It would probably, Mr. Chairman, it would probably be the developer who wants to buy it between now and then, I would think.
Looks like he's going to wait till July 2019.
That's the idea,
Can we
Mr. Chair.
celebrate? Can we celebrate with fireworks in 2019? with
Yes,
the
you can.
conveyance?
I got news for you. They're already setting those off over there in Clark County.
All right.
Move to report.
It's been moved and seconded that the amendment in the nature of the substitute 899 be reported. Please note your vote.
Thank you, Mr. Chair.
Report the vote, sir.
Can I vote myself here? Right now it says I'm McDougal. Okay, I'm happy to vote for McDougal.
Okay.
Okay, thank you.
In intention, the vote is reported 16-0, and the clerk will so note.
Yes, please vote me, Mr. Clerk. Thank you
All
very
right,
much.
thank you very much. Senator Obenchain, you have two bills, sir. Senate Bill 562.
Mr. Chairman, Senate Bill 562 is not a Crime Commission recommendation, but it flows from Crime Commission work. We have millions of dollars in restitution funds that reside in clerks' offices across the state, but nobody's looking for the people who, the victims of these crimes. And the money is going to the Criminal Injury Compensation Fund rather than to the victims of these crimes. This bill is simply a bill that encourages, really it just encourages clerks to try to find the victims. I do have an amendment. I would suggest that we strike lines 221 through 227 of the bill, which is I believe the only mandatory section of this bill that would remove the fiscal impact of this bill, and I would simply create a process by which clerks try to identify the victims. So I move the amendment striking lines 221 through 227.
It's been moved and seconded that those lines be stricken in accordance with what the senator said. All those in favor, please signify by saying aye. Aye. All those opposed, and it is amended as noted. Yes, sir. Any
Said,
members of the committee have any questions? Anyone in the audience who wants to speak in favor? Anyone who wants to speak in opposition? It's been moved and seconded that Senate Bill 562 as amended be reported. If you will please note your vote on the boards.
Roll is open.
Report the vote.
I-16-0.
The bill is reported. Next, Senator, I believe you have 926, sir.
I believe I have a substitute.
Senator Sasslaw moves and Senator Hanger seconds that the substitute to Senate Bill 926 be adopted. All in favor signify by saying aye. Aye. All those opposed, that substitute is adopted. And if you would be so kind to suggest to us what the substitute is doing that the original bill did not, sir.
You'll love this because it.
I bet I will.
It strips out all of the cost and actually should yield a positive fiscal impact for the Commonwealth. Let me tell you what this bill does and doesn't do. This bill is a bill that actually is a pale shadow of its former self. It was introduced a couple of years ago. It passed and was vetoed by the governor. I worked closely with the Office of the Attorney General, with Lane Needler. I worked closely with the counselor to the governor on this in years past. And we made every change that was asked for. And last evening, I spoke with the governor's office, who expressed some concerns about the burdens that this bill unamended was adding to the Office of the Attorney General. And I'm a little bit perplexed because on the one hand, there's a fiscal impact statement, that said this is going to cost hundreds of thousands of dollars for the Attorney General's office to implement these transparency measures in the event that it hires outside counsel to handle cases. But on the other hand, they said, we already do these things, which puzzled me. But rather than resolve that conundrum, I simply said, we'll take all that out. And this bill basically boils down to one thing. When we hire outside counsel to go after money that belongs to our retirees or go after Medicaid dollars that have been diverted, there is a large national industry of big national law firms in Chicago and New York that market these programs all over the country. And they come to Virginia and say, for 40% or 30%, we'll handle this litigation for you. And the fees are absolutely astronomical in many of these cases. And what this bill does is it simply says that we're going to cap the fees. And the cap in here, I think, is a cap that any plaintiff's lawyer, even from a New York or Chicago law firm, ought to consider to be very reasonable. It's $50 million. There is not a case that I can imagine that I wouldn't be willing to handle for $50 million. And I suspect that every lawyer on this panel would agree with me. But what this does is it simply says, and first of all, contingency fees are not for cases like this originally. I mean, they are intended to give people access to the judicial system who cannot otherwise afford access to the judicial system. But out of recognition of the fact that there may be cases in which the Attorney General's office may choose to join other litigation or hire contingency fee counsel, I concede that it's okay in certain cases. And this imposes a 25% cap on the contingency fee for the first $10 million recovered, and then a scaling it up. So what this means is that we are going to be paying less to these national law firms for recovering money, and it makes more money available for our teachers and law enforcement officers and our retirees. So I would ask that the committee take a look at this, and I would ask that this bill be reported.
Okay, any member of the committee have any questions of Senator Obenshain regarding 926? Anyone in the audience who'd like to speak in favor of it? Anyone who'd like to speak in opposition to 926? Mark, here comes some folks.
I hope they appreciate my efforts to accommodate their concerns.
Well, we'll see. Good morning, ma'am. How are you?
Good morning, Chairman. Shari King Casey for the Office of the Attorney
Could you
General.
sort of pull the mic just a little bit to you? Thank you.
Shari King Casey for the Office of the Attorney General. I'm here to speak on behalf of the Office of the Attorney General with respect to this particular bill. I was not aware of the substitute that was just made available this morning, but I do want to speak to specifically the contingent fee limitations in that bill. Various AGs across the country have used contingency fee arrangements to prosecute predatory lenders, retailers who sold children's jewelry filled with lead, securities fraud, pollutant poultry farms, tobacco litigation, and pharmaceutical giants who sold products without proper side effect warnings. Most recently, contingency fee arrangements have been used to go after manufacturers of opioids to combat the devastation brought by these companies on communities all across the country. We need every tool at our disposal to recover the immense damage suffered by those in our communities who've fallen victim to corporate greed and to serve as a warning and deterrent to other companies who would engage in similar harmful
Help me, is this
conduct.
eliminating the contingent fee?
It is not eliminating the contingent fee. According to Senator Obenshain, it is capping those fees, but there's absolutely no evidence that capping contingent fees results in higher recovery for states. In fact, contingency fee restrictions are
But
usually...
wasn't his position not necessarily resulted in higher recoveries by the state, but perhaps the state would not be paying so lucrative? And I'll just tell you, I'm a trial lawyer, so that's my question. The question was, wasn't he suggesting that the reason for the cap was just to save the state some money and that it would not have a chilling effect on those attorneys who would engage in these fairly significant cases?
Well, actually, legislation like this in other states has been deleterious on the state's ability to procure these highly skilled attorneys with significant depths of experience. For example, the conservative
what does
fee
Virginia
caps,
generally pay on a contingent fee case?
the market is about 27%.
So are we having, and I'm not being argumentative, but are we having this debate over 2% on a multi-million-dollar case?
I'd agree to an amendment to increase the cap on the first $10 million to 27%, if that would solve the Attorney General's concerns.
Will that make the Attorney General happy if we amend it to take it to 27%, which would be the national average?
No, sir. The question that you asked me was, what is the standard in the Attorney General's office? That is the standard that's used by DDC in collection.
Well, what
for
is so
collections.
special about Virginia that we ought to see the national standard?
Well, I think there's a market range for that. I think it starts at 27%. It can go as high as 40.
I'm sorry?
It can go as high as 40.
But would the 40 be on an appeal or on the trial court?
I'm not sure.
I'm pretty sure. Okay. So you don't think the Attorney General would accept 27%?
It's not that I would think that the Attorney General would accept 27%. The attorneys who would be bidding for this work
Okay,
would
would it
not
be fair to say that you are not
accept.
in a position to make that decision?
That is correct.
Okay. Okay. All right. I appreciate very much your input. Thank you for coming this morning.
Thank you.
Yes, ma'am. I'm sorry, yep. Did you want to speak?
Yes, sir.
Please come forward. That's a good rule. This happens to be an area I know some about.
Good morning, Mr. Chairman, members of the committee. I'm Rita Davis, counsel to the governor. I'm here to voice the administration's opposition to the senator's bill. I also have not had an opportunity to review the new substitute, but to the extent it just contains the provisions regarding the contingency fee, we still believe it is problematic. Essentially, what the contingency fee cap strives to do is to limit our ability to negotiate on very complex, multi-state involved litigation and use the top talent to do so. That is not in the Commonwealth's best interest. As the governor has said as a repeated touchstone of his campaign and his administration, we need to do the most good for the most people. Handicapping Virginia's ability to compete, to bring liable corporations to bear, and to hire the best talent to do that does not do the most good for the most people. And for those reasons, the governor asks that the committee proceed no further with the bill.
What empirical information can you share with me that the difference between 25% and the national average at 27% is not going to encourage nationwide law firms to take these multi-million-dollar cases on? What can you give me specifically that would support that position?
Mr. Chair, I don't have any empirical evidence to share with you. But the fact that the limiting nature of the negotiation ability, I mean, as we've seen from the tobacco litigation, from the vitamin litigation, this kind of litigation is pursued by very big firms. They expend a lot of talent and resources to get this done. If we want to join in and be on the forefront of some of this litigation and be the state that goes after and vigorously and zealously protects our citizens' interests, we need to be at the forefront and be able to negotiate with that legal talent. And it may not be 27% we can negotiate. It may be 30%. It may be 35%. But if the recovery is $200 million potentially, how has the Commonwealth not benefited from that deal?
What is 25% of $200 million?
I'm sorry, Mr. Chair, you've completely exhausted my ability to do math on that one.
I can tell you it's a damn lot of money.
Yes, I would agree with that, Mr. Chair.
Okay? And I am having a very difficult time. This is so ironic that here you got Senator Obenchain and myself, who are both trial lawyers, that are questioning whether or not we need to maintain that contingency fee level. And that intuitively ought to suggest something to you, that you got trial lawyers who are seeking to cap this. And it is because we are hoping to do more for a greater group of people who happen to be the citizens of the Commonwealth of Virginia, who pay the taxes that fund the AG's office. But I appreciate you are a very compelling spokesperson for the governor, and I want to thank you for being here.
Thank you, Mr. Chairman. Thank you, members of the committee.
Senator Obenchain.
Excuse me.
God, we're both going to get drummed out of the trial lawyers for this.
It won't be the first time. Mr. Chairman, a couple of things. One, I'm just trying to help the negotiating position of the Commonwealth. And it's been my experience, if they are capped by the legislature, they're in a pretty strong negotiating position with these New York and Chicago law firms who may come knocking on the door. And I doubt that a $50 million cap is going to discourage any of these folks from marketing their programs to the Commonwealth of Virginia. I would say that, Mr. Chairman, that this is an eminently reasonable bill, and at the, not at the suggestion, but because the Attorney General's office, well, I guess suggested that it's too low, and they suggested the 27% figure. I'll even move myself to amend the cap on the first $10 million from $25 to $27 million in hopes that that gesture of goodwill, along with the gesture made by stripping out all of the other language rather than negotiating it, may change hearts and minds in the governor's office.
Senator Obenchain, one of the things I've always admired about you is I never thought that you were altruistic. And I got a suspicion this is not going to make peace in the family, because sometimes they just want what they want. So.
But I try.
Well, the good thing about it is if we do adopt this amendment and there's not peace in the valley, when the bill gets to the floor, there was also the opportunity to put a floor amendment on it, cutting it back to 20%.
Indeed.
You know, that's a very viable option.
And if they come and say that 28% will do it, I'm certainly open to that.
Oh, no, we don't want to be that generous.
All right, I move to amend the first block to 27%.
It's been second. It's been moved and seconded that we just give away another $4 million. I'm sorry, it's been moved and seconded that we amend it from 25% to 27%. Any discussion? If not, all in favor of those amendments, please signify by saying aye.
Aye.
All right, ladies and gentlemen, this very generous trial lawyers bill is in front of us. Any closing comments that we want to make at 11:30?
I move to report.
It's been moved and seconded that the bill be reported. Is there any further discussion? If not, please note your vote on the board.
Roll is open.
Report the vote.
Ayes 10, no 6.
The bill is reported. Thank you, Senator Obenchain, for your generosity and
Thank you,
trying to make
Mr.
peace.
Chairman, members of the committee.
Damn right I did. All right, Senator Stewart. Oh, I'm sorry, Mark, you had one more bill. I apologize that I overlooked that. 516, sir? Pardon me? Tomorrow. Okay. Without objection, Senate Bill 516 will pass by for the day. Senator Stewart, I know we've got you under the gun, but we want to give you a fair opportunity for your bills to be heard, sir.
Thank you, Mr. Chairman. Mr. Chairman, I've got Senate Joint Resolution 76, which is the second year of the constitutional amendment for the real property tax exemption for surviving spouses of a disabled veteran. All this does is it allows the spouse to move to another house, and that is the extent of it. And then there's the corresponding Senate Bill 900, which allows it to be put on the put to a vote to the people referendum.
So Senate Bill, excuse me, 170, Senate resolution.
SJ 76 is the second year of that resolution. It is a limited expansion of the property exemption for surviving spouses, which just allows them to go to another house as opposed to being mandated to stay in the one that they were in when they qualified for the exemption. And then SJ, and this is local impact, Mr. Chairman.
SJ 176 goes with Senate Bill 900.
Yes, Mr. Chairman, 176. I thought it was 76.
76, excuse me.
Yes, sir.
You get to be my age, your eyes cross sometimes.
Mine too, at my age.
All right, ladies and gentlemen.
That's it.
Does anybody have any questions of Senator Stewart on SJ 76 and Senate Bill 900?
Yes, Mr. Chairman.
Okay. Is anyone in the audience who wants to speak in favor?
Yes, Mr. Chair.
Yes, sir, very briefly, if you would.
Very briefly, yes.
Thank you for being here, though.
Thank you for a few minutes. Very briefly, I'm Bob Sempak from the Joint Leadership Council, Assistant Legislative Officer. We are totally in support of both of these bills. Thank you.
I'll tell you what, you get the award for today. All right, anybody wants to speak in opposition? It's been moved and seconded that in the block Senate Joint SJ 76 and SB 900 be agreed to. Please note your vote on the board.
Roll is open.
It's opening. There it is. Boom.
All right, report the vote, please.
Ayes 16, no 0.
Great. Your next bill, sir.
Mr. Chairman, I have Senate Bill 880. I hope that this one goes as easily and quickly. I suspect it won't.
Senator Hanger moves and Senator Ruff seconds that an amendment in the nature of the substitute to Senate Bill 880 be adopted. All in favor signify by saying aye. Aye. All those opposed, and we have the amendment in the nature of the substitute before us.
Mr.
Yes,
Chairman,
sir.
hopefully that amendment in the nature of the substitute either makes that, gives the locality the ability to elect, is what I was hoping for, as opposed to requiring, there are only two counties that have this condition, West Point and Colonial Beach. West Point's in King William. They don't want to participate. Westmoreland has Colonial Beach school system, which negatively impacts the county's portion of the composite index. There is a fiscal impact, as I'm sure you've seen, but this has come at the request of the locality.
Senator Hager.
Mr. Chairman, I had a bill previously where dealing with the composite index that we continued, and it appears to me that this probably could be a subject associated with that for these small school divisions. And quite frankly, Senator Stewart, I don't know where you're at on this, but I'd like to provide some incentive for Colonial Beach to consolidate with Westmoreland, if we could do that.
Mr. Chairman, there are a lot who would agree with you, but there are a lot who would not too. It's a touchy subject.
Senator Hanger, in the interest of time, let's dial back into reality. here for a
Okay,
minute.
I move that the bill be continued to 2019.
It's been moved and seconded that Senate Bill 880 in the world of reality be carried over until 2019. All those in favor, so note once it's open. Report the vote, sir.
I-16-0.
Thank you,
All
Mr.
right.
Chairman.
One more, I think, Senator Stewart.
He's all ready for it.
259.
Yes, sir.
I'm sorry, Mr. Chairman, I don't have my, I'm just
Helping-
looking to see which one it is.
Oh, yes, Mr. Chairman.
And let me say, Mr. Chairman, Senate Bill 259, I bring this year after year, and I understand the fiscal impact of it, but I think it's important to keep it before the committee and the General Assembly because it's such an important topic. And you all know what this does. I don't need to explain it, but it extends those benefits for education for spouses of disabled veterans. And I would just ask the committee to consider if their money becomes available, we sure would like to try to help these folks extend this education benefit.
Simplify, sir.
Thank you.
Any questions, anybody of the committee? Anyone who wants to speak in favor? Yes, sir. Mr. Brevity, you're going to try for 2 gold stars in the same day?
I don't know if I'll make it. We do also, the JLC endorse this bill and support it. Thank you.
Thank you very much, sir. Anyone who wants to speak in opposition? Ladies and gentlemen, the committee, Senate Bill 259, which while the number may be new, the subject is not, and Senator Stewart has really been a advocate for this for a number of years. The bill is before you.
Mr. Chairman.
Yes, sir.
Senator Stewart has done his job, but I suspect we should go ahead and just pass the bill by for this year. So I would move that we PBI the bill.
Is there a second?
Would y'all rather?
You want PBI or pass?
Would you rather continue it, leave it on the table?
Well, Mr. Chairman, I would love to leave the discussion open if that's possible.
Okay, Mr. Chairman.
The motion is amended. It's been moved and seconded that the bill be carried over to the 2019 session. All those in favor, please note your vote on the board.
Roll is open.
Thank you, Mr. Chairman.
Report the vote.
I-16-0.
Does that mercifully complete the docket? With that, the committee will rise if you have the energy to go.